But today, I have some personal difficulties. So may I pray IP 28, maybe taken out after zero baby. Motion matter. I have taken consent from other fellow.
28 listed on 21st.
My lord, I beg to mention item number 37. As per the instruction of my client, my lord, I am not pressing this petition, my lord.
Mr. R. Islam submits that his instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Much.
It's also matter that for letting of an admission matter, immediately application matter. Petitioner has been suspended for last 1 year, my lord. And 124 related, my lord.
27.
May I please, my lord? This motion matter, my lord, unlisted. Can it come today? The urgency is, my lord, here is that the person is with physical disability. He was appointed, he was selected in the post of junior assistant. But now when the medical board, in that junior assistant, they have gone for a medical examination. In that medical examination, that board has said that I do not possess 40% disability and I am not eligible for appointment, my lord.
So what is the urgency?
My lord, that vacant post will be gone, my lord. Actually, we mentioned it earlier yesterday, but it did not came, my lord. Kindly consider it for today.
No urgency. We'll have it on 19th.
Obviously.
Okay,
May
okay.
Lordships, I have a similar,
We'll have a unlisted. We'll take it up if time permits.
Okay.
I've already 46 motions.
Okay, we'll.
So if it permits today.
Okay. Obviously.
Wait, legal lordship, my lord. Beg to mention for listing of a contempt case, my lord, for orders after vacation immediate, my lord.
21st.
Obligation.
Please, Your Lordship, I beg to mention item number 1, Lordship, kindly pass over for the day. Some difficult day, Lordship.
Huh?
Some difficult day, Lordship. Kindly pass over the matter for the day.
Item number 1.
1.
Okay, 21st.
May it please, Your Lordship? Your Lordship, I'm praying for moving of a matter unlisted, Your Lordship.
Today,
Yes, Your Lordship.
what is the urgency?
Your Lordship, a transfer order has been passed by the Joint Director of Health Services, which is in clear violation of the Mission Director, Your Lordship.
Okay, okay.
Obliged.
Your Lordship exactly mentioned for listing of a matter for orders, Your Lordship, after vacations.
Orders. 21st.
May I please, your lordship? Also, I beg to mention for listing of a matter for withdrawal on 19th. Obligation.
Item number 27. Item number 27. Person Congress senior and contributor Islam immediately admitted for death.
Huh?
Congress senior counsel and Mr. Islam. Admitted for press. That's what that was authorized.
27. 21st.
may please Lordships,
Yes,
Lordships, I had made a mention yesterday for listing a matter before your Lordships today. Sadly, the registry has not listed it, saying that it is a bench 2 matter. It is not a bench 2 matter, your Lordships. It's a recruitment matter. In fact, one of my learned friends has just mentioned the urgency is that it's a state recruitment level board.
recruitment of what?
Lordships, it was for a recruitment of grade 3 and grade 4 posts, and I had applied for a grade 3 post. I have
No, no,
already
in
been
which
selected.
department?
Lordships, the thing is that the entire selection process is conducted by the state level recruitment commission, and thereafter we are allotted different departments
Recruitment of what?
of grade 3 and grade 4 posts in the state of Assam
Grade 3
across
and
all.
there can be grade 3 and grade 4 posts
Yes, your
in
lordships.
schools
So-
also.
So 1760 posts were advertised, and it was a common selection for grade 3 and grade 4, and then thereafter an allotment is given by the government to give as per the department. Now the department which has been allotted to me is the education department, your lordships. So
Go there.
now my lordship, my problem is, in fact, just my learned friend, one of my other friends has also just mentioned a matter, similar matter, your lordships. They are issuing appointment letters tomorrow and day after, your lordships. That is the urgency in the matter. And we are not concerned with the education department, but it is because it is the state level recruitment commission for grade 3 and grade 4 posts, which has actually issued the impugned order rejecting my candidature as a person with disability.
Problem
saying-
which happens is if it is an education matter, we don't get the education councils here and
No,
the
it is
matter
not a-
gets adjourned.
It is not an education matter, your lordships.
Okay. Okay.
I am deeply obliged.
Yes.
This case, the petitioner is a family member of the martyr, lordship of the Assam government of foreign lordship. Accordingly, lordship, the petitioner has submitted a representation, lordship. Your lordship will file a case number 43.
Why should you be appointed in any vacant post?
Lordship, in terms of the Assam Public Service Financial Rules, lordship, that can be appointed, lordship, considering the law exams in the lordship that was introduced by the legislature.
Huh?
The law Assam Public Service, lordship, differential appointment rule 1999, lordship.
What has happened? What is your right to be appointed?
No, it is preferential lordship. Only preferential lordship. If two candidate arises in the same position lordship, he may get the preference lordship. There have some specific.
Assam agitation,
Yes, lordship.
Lordship,
family member.
yes. Only representation, lordship, only in the case of the petitioner.
Where is your representation?
Your lordship will find at page number 43.
You gave in the year 2021 and you are approaching in 2026.
In the meantime, lordship, there was a process that was carried out by the department itself.
No, you have come after 5 years. Why on earth should this court issue notice in this matter?
Because lordship, the agriculture department has observed the formalities and accordingly out of lordship, two candidates, those who approach before this honorable court in the year lordship, your lordship will file at page number lordship 46 in the year 2019 lordship. They have been appointed and these subsequent other candidates, their proceeding has been, they have processed for further consideration. But subsequently, lordship, their appointment has not been made or lordship, their representation has not been considered till today, lordship.
You all give your representation in 2021 and this court should direct them. Go and submit a fresh representation and come back.
Yes.
This is not the way. You can't come. No, Mr. Sharma. Otherwise, I dismiss it on delay and latches. You don't have any right out there. There's no continuing right. You give a representation in the year 2021 and you come in 2026. Sorry. I have heard Mr. D. Sharma, the learned counsel appearing on behalf of the petitioner, and Mr. J. K. Goswami, the learned counsel who appears on behalf of the respondents, and Ms. So-and-so who appears on behalf of Agriculture Department. Mr. D. Sharma submits that the petitioner would be well advised to submit a fresh representation claiming appointment on the basis of the Assam agitation. On the basis of this Assam, what is that name? What is the name of the case? Assam Public Service Preferential Appointment Rules 1999, taking into account that the petitioner had last submitted the representation in the year 2021. It is observed that in the circumstance such representation is filed, the respondents shall duly consider the same. And if the petitioner is still aggrieved, the petitioner is given the liberty to again approach this court. Pray.
Yes. But after this, particular proceeding initiation by the petitioner was dismissal from service, particularly petitioner file appeal by.
Why appeal has not been disposed of?
Lordship, that appeal has been preferred to the finance by the finance department, through the finance department. So the finance department has to answer, Lordship. I'm for the PHE.
Finance department is not here. How long it has been? When did you file the appeal?
On by the 15/8/2025. This by the page 10.
Yes, finance. Why you have not disposed of the appeal?
Lordship, here.
What
Lordship,
is your instruction?
Lordship, this is coming for the first time, Lordship, may I just.
What? For the first time? This has come for after 3 months.
Lordship. Huh?
You
Oh.
take 3 months to obtain an instruction
No,
in
no.
respect to an appeal not being disposed
No,
of.
no, Lordship, not.
Isn't it the most saddening part?
No, Lordship, here, Lordship, we don't know Lordship, the status regarding the appeal, Lordship.
Uh,
So Lordship may fix it immediately after the vacation, Lordship, I'll obtain.
we will fix it immediately after I rise at 11 o'clock, 12 o'clock at 12:15. That is the maximum I can accommodate.
Lordship, 2 o'clock, Lordship at two.
Take a disposal then. If you don't get that instruction, I'm directing you to dispose it off within 1 month.
Lordship.
Therefore, heard Mr. Ellen Dihingia, the learned counsel appearing on behalf of the petitioner. Mr. A. Solia appears on behalf of the finance department. Mr. R. Gokoi appears on behalf of the
PHE, respondent number 5. Respondent number 5, Your Lordship, PHE department.
PHE department, and Mr. C. Burwa appears for the accountant general. Accountant general. Full stop. The petitioner herein is aggrieved by the delay in disposal of the appeal filed by the petitioner against the dismissal order dated 27/3/2025, passed by the Secretary, Government of Assam Finance Establishment B Department in the departmental proceedings initiated against the petitioner. It is seen that the appeal was filed as on 14/8/2025. Full stop. On account of the delay in disposal of the said appeal, the petitioner has approached this court, taking into account that what is your age? You are a pensioner.
No, Lordship. 58.
Taking into account that the petitioner is the sole breadwinner of the family. And on account of the dismissal, the petitioner has been on account of the dismissal which the learned counsel appearing on behalf of the petitioner submits to be illegal and completely in violation to the principles of natural justice. Full stop. It is noticed that upon filing of the petition, this court sought for instructions from the finance department by an order dated 28/11/2025 as to what steps have been taken by the appellate authority as regards the appeal so filed by the petitioner on 14/8/2025. Full stop. It is disheartening to take note of that the counsel appearing on behalf of the finance department, however, have not been able to provide any instructions in that regard. It is the opinion of this court that the disciplinary authority or the appellate authority cannot delay in disposal of the appeal, more so when the appeal has been filed challenging a dismissal order. So consequently, this court therefore disposes of the instant writ petition with a direction upon the appellate authority to dispose of the appeal so filed by the petitioner on 14/8/2025 within a period of 2 months from the date a certified copy of the order is served upon the commissioner and secretary to the government to the secretary to the Government of Assam Finance Establishment Department.
Lordship, if not already, Lordship,
Full stop.
if there's a possibility it might have.
It is further observed that in the circumstance that as this court, for the sake of clarity, this court, however, observes that in the circumstance the appeal has been disposed of, the petitioner be forthwith intimated in the meantime, have been disposed of in the meantime, the petitioner be forthwith intimated, full stop, liberty given to the petitioner if the appellate decision is against the petitioner. Same order. Disposed. You are there.
Yes, Lordship.
Disposed. Yes, what is this?
My father died on 2019, my lord. And there is some amount, my lord, in the account of my father's, my lord, GPF, my lord. So I pray, my lord, that amount, my lord. We have signed a, my lord, notice, and they have replied with that.
My lord, we had gotten instructions.
Yeah, they can be just
Yes.
my mistake.
তাৰমানে প্ৰচেছেই হোৱা নাই।
Yes.
I have already submitted all of these documents, my lord.
So nothing remains.
Nothing else.
Heard Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner. Who is appearing for the accountant general? Who appears for the other soil?
P. Hazarika for 1 to 4.
So and so appears for the respond numbers 1 to 4. And Mr. Soy R.K. Talukder appears for the respond number 5. The petitioner herein, who is the daughter of late
Ganga Vishnu Bin, my lord.
huh?
Ganga Vishnu Bin.
Ganga Bishnubin, had approached this court seeking appropriate directions that she be paid that a legal notice so issued dated 16/10/2025 be considered, and further a direction that she be paid the GPF dues, being the daughter of and the legal heir of late Ganga Vishnu Bin. The petitioner also have sought for compassionate family pension, being the daughter of late Ganga Vishnu Bin. Full. It is seen that in pursuance to the legal notice issued by the petitioner on 16/10/2025, the office of the respondent number 5 have duly intimated the petitioner by the communication dated 1/12/2025 to the effect that the petitioner would not be entitled to any family pension, taking into account that she is already married. It is also mentioned that as regards the GPF dues, the petitioner would be paid the said amount subject to the petitioner being nominated by her father. Full stop. It is also mentioned that in the circumstance there is no nomination, the petitioner would have to obtain a succession certificate from the court of law for the purpose of GPF withdrawal. Full stop. The said communication dated 1/12/2025 is kept on record and marked with the letter X. Full stop. In that view of the matter, nothing further. Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner, submitted that in the meantime the petitioner had already submitted
Aadhaar card and my lord, the death certificate and passport size photograph. I have submitted.
No, are you nominated or not?
I'm not nominated. my lord.
So have you taken the succession certificate or not?
Actual certificate I have taken.
So then,
My lord, they told me, my lord, they will allow. So only they have.
Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner, submits that in the meantime the petitioner is taking appropriate steps in pursuance to the communication dated 1/12/2025. In that view of the matter, nothing further remains in the instant writ petition, for which the writ petition stands closed. Same, same, কালি এটা যে order দিছো সেইটো।
6, 8, and 10.
Huh?
6, 8, 10, and item supply 54.
Item number 6,
Item number 8,
8,
item number 10,
10,
and supplementary item number 54. There is one more item where Mr. G. Chakraborty appears, that is item 11. Item 11. So, I feel tag line.
let us see, but your case is, I give you the liberty. You challenge it, you don't challenge the clause as 6.5, but say that the fixing of a date is arbitrary. Take into account the Delhi High Court judgment, huh?
So,
Because if you challenge, there is a problem out there, but you challenge it in this manner. Okay, hey, kali eta order disu no. Ketaman, egita di disposed.
8, 10, and 11. Supplementary.
You give the number. Huh? 11 না লাগে, এইকেইটা আমি serially যাই লওঁ। এওঁৰ এইকেইটা শেষ হৈ গ'ল। ঠিক আছে, 11 টো serially লওঁ। প্ৰথমতে এওঁ আছে ন, এওঁটো শেষ হৈ গ'ল। You have given the number, na? 6,
8, 10, and supplementary item 54. Obliged.
I am appearing in this matter.
Where the agent workers engaged in the forest department, forest division. We have completed more than 14 years with the continuous.
Worship, it can be disposed of in terms of Upendra's judgment, I think. Covered case, it appears, Lordship, subject to verification.
is the case of the petitioner covered?
Covered.
Like this order?
Petitioners are asking for minimum of the pay scale, Lordship. For that, the entire service period, whether they'll be covered or not, Upendra's will come, and in the orders also, which my learned senior friend has annexed, Lordship, the authorities were directed to verify whether or not they will be covered under the Upendra judgment, and if so.
No, kindly see page 48. Considering the same, the respondent are directed to grant the benefit of minimum in terms with so and so.
Yes,
Before granting, the
them-
petitioner will be at liberty to make necessary verification as may be required.
Yes,
The
Lordship.
petitioner be afforded the minimum say as directed herein above expeditiously as possible and preferably within 3 months from the date of receipt of the.
Upon verification.
No, that is a big problem. Don't you think that? Be
Yes.
afforded. So the question is whether the petitioner is entitled is a subject matter of consideration.
Yes, Lordship.
If it is found that he is entitled,
Yes.
then only the payment will come.
Yes, that is why the verification.
And but 3 months is too less. Don't
Yes.
you think?
Yes, Lordship, that is.
You can't do it. It will amount to contempt later on.
That verification needs to be done, Lordship, and the Lordship will need to observe and see whether it's covered or not, Lordship, because it is a claim of the petitioner that they are similarly situated.
But what happened? Because they are all working in BTC.
Yes, Lordship.
But with the BTC's decision out there, whether Upendra's will apply, because you see, it was a consensus decision in Upendra's. Kindly come to this. You first of all should know what to say. Kindly see Upendra's judgment. Kindly look into this. Kindly see paragraph page 71. It is, however, heartening to learn that the state government has agreed not to terminate the so-and-so and similarly placed employees working since the last more than 10 years, not in sanction till normal retirement, except on disciplining so-and-so. But this is the concession given by the state.
Yes, Lord.
But whether BTC is bound by that,
Worship,
I have no problem in passing an order. If they get it, it is well and fine. But you should know what to say, whether the BTC is agreeable with this. You take an order to that effect. Later on, the BTC comes up. You cannot later on say that.
Worship, then in that case, let me complete my instruction, Your Lordship. If
What did you do? That is what you have been asked on the last occasion.
Because in Upendas, it has also been stated that they have to have 10 years of service completed.
10 years of service, but it was a concession by the state.
Some of the
But
petitioners-
are these salaries of these persons paid by the state or by the BTC?
Yes.
Then
Employment has been done, Lordship.
be careful a bit. Who is going to pay?
Some of the petitioners, they have been appointed in the year 2010, Lordship. That is why that verification, the end of the day, Lordship, the approval of the.
No, there is no problem. Passing an order for verification and as to whether they get it. Now the question is whether the BTC would agree with this.
Lordship,
Hello.
as per
Let
this,
us direct. As he says, we'll dispose it of in that time.
The verification handle. will be-
That I will say. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. N.R. Sharma
Lordship,
appears on behalf of the BTC. Mr. A. Solia appears on behalf of the Finance Department of the Government of Assam. Hussain. It is the case of the petitioners that the petitioners were appointed that all the petitioners herein were appointed as casual workers, isn't it? Casual laborers. Casual laborers by the Forest Department under the BTC.
BTC, Sirang Division, Sirang Forest Division.
All are Sirang, na? All are Sirang. Have been appointed as casual laborers in the year 2006, 2005 and 6, 2005, 6 and 7, no, 2005 to 10, 2005, 2006, 2007 and 2010. The present petition has been filed by as many as 8 petitioners. Who are the petitioners appointed in 2005?
My lord. Petitioner number 7, my lord.
Right? You don't know, mister. Kindly see page 16. It is 2006. 17 is 2006. 18 is 2006. 19 is 20 is 2006. 21 is 2010. 2022 is page 2005. Get a silo, huh? The petitioner, 8 petitioner, who stop? Annexure A to J. Annexure A to I. Are the various certificates issued by the range forest officer as well as the forest, the various certificates issued by the range forest officer as well as the forest beat officer of the Sirang division Klung range.
Kuplung, my lord.
No, এনেকে লেখো। Annexure A, B, C, E, F, and I are various certificates issued by the Range Forest Officer, Puklung Range, and Annexure G and H are certificates issued by the Forest Beat Officer, Kazol Headquarter, Kazolgaon, certifying that the petitioners herein were appointed as casual laborers on or before 2010. The case of the petitioners herein is that in terms with the judgment of the learned division bench of this court in the case of the state of Assam versus Upendas, dated 8/6/2017. It was reported, this is reported, na?
Yes, 2017, what you have.
Reported in so and so. The petitioners herein are also entitled to the minimum of the pay scale
JLD 60.
as has been granted to similarly situated employees by the learned division bench of this court in the case of Upendas Supra. It is the further contention of the petitioners that the learned coordinate benches have also passed similar orders in that regard. When the matter was taken up by this court on 16/12/2025, this court directed the Standing Council of the respondent numbers 4 to 8 to examine as to whether the judgments orders passed by the learned coordinate benches in WPC number 5814/2024 and WPC number 4196/2025 would cover the cases of the petitioner. Today, Mr. N.R. Sharma, the learned counsel, appearing on behalf of the BTC, submits that the cases of the petitioners herein would be covered. The petitioners herein are similarly situated with the writ petitioners in WPC number 5814/2024 and WPC number 4196/2025. Full stop. Mr. A. Solia, the learned counsel appearing on behalf of the finance department, however, submitted that it is only after proper verification is being conducted and the petitioners and it is found that the petitioners herein are similarly situated with and found that the petitioners herein have rendered "10 years of service not in sanctioned post with effect from 1/8/2017. have been working since last more than 10 years, bracket not in sanction post with effect from 1/8/2017. Such petitioners would be entitled to and not others. He therefore submitted that only after verification is being conducted, the petitioners can be granted, and if found entitled to, can be granted the minimum of the scale of pay.
Right, so proposal has to be sent by the BTC authorities.
Pustav. Now, this is okay. That is another aspect. Pustav. Taking into account the above, this court therefore disposes of the instant writ petition with a direction upon the respondent numbers 4 to 8 to verify as to whether the petitioners have been working continuously since last more than 10 years, not in sanction post with effect from 1/8/2017. And upon verification being conducted, if it is found that the petitioners herein are entitled to, the petitioners be paid, be given the minimum of the pay scale as has been directed by the learned division bench in the case of Upendas. This court further is of the opinion that the said aspect, that the entire exercise be completed, is of the opinion that this court further directs that the entire exercise be completed by the respondents herein jointly and severally within a period of 6 months from the date a certified copy of the instant order is served upon the respondent number 4.
Hesitation cut mark was not.
Huh?
Because hesitation cut mark here lordship, their candidates are say defective. But in fact, well,
Hesitation cut mark on the left forearm.
case 52 years.
Then
In fact, your lordship, there was no any deformities here lordship. They have assumed that the hesitation cut mark indicate that these are
It is comes under psychotic,
but the
psychological problem.
department your lordship has given of
oh, hesitation, cutting a wrist,
Self-harm,
suicidal.
suicide, the self-harm.
You're suicidal.
only the,
Yes, therefore it is referred to the psychologist.
but the psychiatric department has given their opinion that whoever.
Where? Prior to that.
Yes, 52. 1 or.
Huh?
Sorry. Yes, 55, 1 or 4.
So that is subsequently.
Yes.
So
No, no.
again, same order.
My lordship kindly have a look. In
Same
the
order.
review medical examination, your lordship.
Same
they have
order, same
they have been
order.
referred to the GMC.
Submit all these things
The
there.
doctor who-
Mr. Unless these opinions were, subsequent opinions were brought to, were within the knowledge of those authorities prior to that, and they have taken a decision, any other order can be passed. But if these orders, opinions are subsequent to the review medical board's order, that order follows.
But in my petition, I have made a statement, your lordship. The review, the doctor, the concerned doctor who conducted the medical examination of the petitioner, they suggested the respondent authority to bring the petitioner on the next day. On preliminary inquiry, the concerned doctor has given opinion that no abnormalities have been found. But without considering that they have given that opinion, Your Lordship.
These opinions of the GMC subsequently?
Yes, that is subsequent, but the concerned doctor has, the concerned doctor on preliminary inquiry, the concerned doctor, can you have a look here, Lordship, can you get six?
Raise all these issues in the representation which you are submitting.
My case is that they have no any abnormalities. The concerned doctor has given opinion that on preliminary inquiry, we have not found any abnormalities. And the respondents have been, was suggested by the concerned doctor to bring the petitioner on the next day for further examination.
Who has asked?
The concerned doctor, Your Lordship.
Of
Concerned
which-
doctor, Your Lordship, the review medical authority brought the petitioner before the GMC, and on preliminary inquiry, the specialist doctor specifics of my petition, kindly have a look. Therapy.
I'm taking back this.
Yes,
If you don't make out the case, stay to note there, but it will go for dismissal. Okay, then.
Yes.
Take your chance now, tell me. Otherwise, you are getting that order. Now, let's see.
yes.
Hesitation cut mark on air. Where is that concert department? The doctor asking you?
Lordship, I have made a statement.
Statements won't do. Statements won't do. Again, now this is a case for dismissal now. Now it's a case. No,
Trying to-
division bench. No, Mr. Khan, this is a case for dismissal. This is here. To liberty to the another. No representation.
Lordship, I have made a.
Hesitation cut mark on the left arm. Then refer to clinical psychologist. Who has referred? Full diagnosis. This was done on review medical board's decision is on 2011, 2019, 11. There are 3 persons.
2%, Your Lordship. But the petitioner number 2, in the last year, he participated. But in the last year, he,
Unfit, examine multiple hesitation cut marks.
it is there.
Multiple.
Simple cut mark was there, Your Lordship. But
Published medical literature for hesitation cuts on non-suicidal iman mentions that so and so, so and so. This is in terms with clause 2, na? Of the guidelines?
Yes, Lordship.
2, they have provided this. So that case, we dismiss it right away.
the petition number 2, in the last year, he.
Mr. Khan, are you taking that first order or not? Go do whatever you have. First order to the review. Agreed, go to the review. I am not going to look into all this stuff. Yes, Mr. Chakraborty. This is a matter which has been admitted. Why should I take it up? Come up for admission. Have you filed your affidavit?
Again, the problem remains, my lord, here. Again, similarly.
6.5 has not been challenged. Chalo. Hey, order to Nishna. That order you pass?
Here, his OBC non-clear certificate is after the financial year 24-25.
That is the thing.
Financial year 24-25 is okay. But as on the date on which the verification was done,
Yes, sir.
as on that date, did he have the certificate? My question is that. Because if you see 6.1, it says that certificate is only be seen at the time of verification. Now, as on that date, now the only thing is, why on earth have you made the closing on 14/9/2024 when you are asking for the examination, educational qualification on 1/1/2025 and the age is also 1/1/2025.
Yes.
So therefore, there has to be some reasonable nexus. And when you are looking into it, further to that, there is a division bench judgment of the Delhi High Court.
Yes.
Now, otherwise that High Court's decision, though persuasive, but it has lends more credence out here in this case, taking into account that most of the central government litigations are there.
Yes.
You have to understand that. So there, if you have not filed an appeal against that order, then it would be binding upon you in all other matters because it's the order against the central government.
Yes.
So that is why I have allowed them to withdraw with liberty. not to challenge 6.5 as it is, but to say that it is arbitrary, in fact, conflict with event death clause.
Yes.
You see that order which I have passed yet, withdraw with liberty.
I had filed a RTI application.
What is this?
Also, I filed a RTI application seeking certain information.
I think an impugn letter dated passed by the district whereby it is been tried to dispose of the first appeal for not furnishing requisite fees filed by the petitioner. Instead, he has attached the proper fees along with the first head. What? What is the case?
Lordship, although the information has been provided through, it is mentioned that the information should be get in the portal of the district judiciary of Lakhimpur. But the petitioner could not find anything, Lordship.
What? Where? What are these orders enclosed?
Lordship.
Your application for appointment of grade 4. You are applying for grade 4.
So I have already doing the job as a temporary basis since 2020.
As a?
Since 2001,
What are you working as?
grade 4 employee on temporary basis.
And then? What do you want?
Subsequently, I have been removed from in the year 2022, Lordship.
You have been?
Removed from my job,
2022.
22.
And then?
Lord, subsequently, I have filed a RTI application pertaining to the appointed candidates in various advertisements published by the establishments. Lordship. Thereafter, the PIO had provided me the information stating that the information were available in the website of the portal of the Lakhimpur District Judiciary. I could not find any information there, Lordship.
So file appeal.
Yes,
19.
I have filed a first appeal there. But whenever I went to the office of the district judiciary, they have refused to acknowledge my receipt. Thereafter, I constantly to find the sent through registered post Lordship. Registered post along with the rupees 10 rupees. But the authority had rejected my first appeal on the ground that I had not deposited the rupees 10 Lordship. Rupees allowing the first appeal.
Then file second appeal.
I have already signed second appeal, filed a second appeal before the Central Information Commission.
Then?
But the same is pending, Lordship.
So what should I do? What can I do when the second appeal is pending? No, you are worried with which order? Why are you filing this RTI? Tell me.
Lordship, I am fully deprived because I am serving.
So your basic is not with this. Why you are unnecessarily filing all this type of litigation? Your case is that you were working appointed in 2020. 2001. You worked till 2020, 22. Isn't it? And you have been thrown out. Now, therefore, why you are not fighting that litigation? Unnecessary fighting all other litigations? Where is it? You were there earlier. What is this RTI is hereby terminated on a man who was temporarily appointed as a casual in the establishment with effect from a man with a man. By the order dated. You have, where's your first appointment order?
Annexure 1.
Why you are not challenging these type of orders? 25, 2022, unnecessary filing all these things. What is going to help you with this RTI business? What is your RTI you sought for?
RTI application is page number Annexure 5. Annexure page 20 Lordship.
Huh?
Page 20.
Your name is what? Rajan Neo. Public information. How many are appointed in various posts in the below mentioned several advertisement published? Advertisement. Please provide me all the names of such appointees. Please provide me all the names of Provide me the names of selected members of the remand. How many remand? Okay. Now, what is the report which is being given? Query details are available. Advertisement. How many incumbents were appointed in various posts? in the below mentioned several advertisements. Details are available in the official website of the Lakhimpur Iman. Kindly visit the same. Please provide all the names of the so and so Iman. The names of the selected candidate in respect of the Iman are available in the website. Yes. But you are not providing the information.
Lordship, firstly, he had participated in a selection process long back, Lordship.
No, I am not on that.
Lordship.
His only grievance is that look here, I have sought for certain information. This information has not been granted.
Lordship.
Okay.
Lordship.
Now he has sought for this. You say that this is available. Okay. So just file one short affidavit
Lordship.
giving the information. Matter over. Isn't it?
Yes, Lordship.
Lordship.
Give the information which is there. Why you are you have the information.
Lordship.
You say kindly go there to the district judiciary. You could have very well taken out the printout and given it to him. Unnecessary litigations.
Lordship. Lordship, we have received instructions today
Show
morning.
me. Mister, kindly look into this. What do you mean by this? E, page 21. Please provide me the names of the selected members. Page 21. What do you mean by this?
Lordship,
What are you asking?
Lordship, in the, there was no written examination when the interview was held, Lordship.
No, I'm asking. Please provide me the names of selected members of the selection committee. Means, what do you mean by that?
The first-
Selected members of the selection committee or notification order by which the aforesaid selected candidates were appointed in various posts. What do you mean by that? Your question is wrong, don't you think?
Yes, Lordship.
Well, please provide me all the names of the said appointed or selected candidate in respect to the aforesaid advertisement and their appointed orders. Okay, A is okay. How many incumbents were appointed against this advertisement? You want that? A. B. Please provide all the respective credentials or documents, including their respective applications for seeking appointment. And yeah, this C can't be given.
Yes, Lordship.
8 will affect it.
Yes, Lordship.
D. Please provide me the marks allotment sheet given by the members of the jury in respect to the aforesaid advertisement. Why do you need this?
Lordship, because I was also,
A candidate.
I was also one of the candidates in the particular advertisement, Lordship. But
Now you were a candidate in which exam? All the 4.
yes, Lordship. But no written examination was held, only oral interview was there, Lordship.
As regards D, provide me the marks allotted sheet. This is available? Madam, kindly see page
Lordship.
21.
Lordship,
Whether D, this information is available in the official website?
I have to take instructions regarding this
Huh?
lordship. To take instructions.
No, kindly see here. D.
Lordship.
Please provide the marks allotment sheet given by the members of the selection committee in respect to the aforesaid event. Details are available in the official website of the district judiciary. You say so. Let us open and find out whether it is there. Else we are going to take action against this chief administrative officer if you have made a false statement. This 100% this would not be available. No website will provide these detailing of these marks which have been given. Why you are taking up these type of things? Secondly, he has filed an appeal. Now, where is that order? But Mr. Counsel, the problem is you have, why did you approach the State Information Commission? How do I help you with this? It is only after the disposal of this I can do. You take a decision on this and then come back. You see, if you have not filed this state information, I would have very well directed them to accept and decide, give information. But as of now, I can't. Because we have already approached some other authority.
Yes, Lordship, but the same has been pending since the month of March, Lordship.
The March, it can't be from the month of March. Who appears for the State Information Commission? Have notice been issued?
No lordship.
Mr. Counsel, Assam Information Commission represented by State Information, yeah. But that is not also your prayer, na? How can it be from the month of March?
Lordship, sorry. 6
You filed it recently, must be.
6 August 2020.
Huh? When did you file this? 6/8.
6 Lordship.
Then?
6.
And all these reliefs can't be granted to you. Okay, we do one. Who appears for the State Information Commission?
D. Decca lordship. Mr. D. Decca.
Deputy Decca, Lordship.
D?
D. Decca lordship.
Who is D. Dekar?
Deputy Decca, Lordship.
Deputy.
Deputy Decca.
Have you served a copy upon him?
Yes, Lordship.
And he has not appeared. His name is shown.
Yes, Lord.
Huh?
Yes, this is
Lordship,
not the fraud.
Notice has not been issued lordship.
Notice, it's not.
Is the standing counsel?
Yes, Lordship.
Lordship.
Okay. List this matter again on 21st of January 2026. First of the matter has been adjourned on account of the standing counsel of the respondent number 1 being not present. Though his name, item number kiman asil? His name is not shown, na? There's a standing counsel.
Yes, Lordship.
Lordship.
So, and again, let's this matter again on 21/1/2025-26. And name of Mr. D. Dekar. What is full name?
Deputy Decca, Lordship.
Deepjyoti Dekar. I could see him. He was here, na? Is that the same counsel? D. Dekar. Standing Council of the State Information Commission. The name of Mr. D. Dekar, Standing Council of the State Information.
The petitioner agreed by the suspension order, that is page 35.
What case you have?
My lord, already 3 months expired, no.
What 3 means here? You were suspended on 11/12/2025.
With effect from the date of arrest, ma'am. With effect from the date of arrest,
Ah, nothing.
11/9. In order reflects, ma'am. Page 35.
They may not have known about your arrest.
That it reflects, my lord, they have intimated.
You are Mr. D. Dekar. Then where were you when the matter was there? Loitering around in the corridors. Then catch hold of the petitioner council. We'll take it up. Then what is there? Your case.
By the authority on 12th. That reflects the.
Why you have been rejected?
My lord, I was arrested in connection with my case, that is page 26.
When did you get the bail? 23/10/2025. So
Well, on 12th night.
where is your suspension order?
That is page 35.
Report from the Joint Health of Service received from the Director of so-and-so in connection with the arrest of Dr. Nazir Khan Hussain so-and-so, and later information received from so-and-so in connection with so-and-so case and deemed to be present on duty and in view of the Governor of Assam, therefore, in exercise of the powers conferred on the 9/2 is pleased to order that he is deemed to have been placed under suspension from service with effect from the date until further order. The headquarters will be the place at which he has been debarred from private practice and other. He is allowed to draw subsistence allowance. Okay. Now he has been brought out on 23/10/2025. Madam, so have you given him the charge sheet? Give him the charge sheet.
I have to obtain instructions, Lordship.
Okay. Now,
Notice
you,
will be
what is this? Earlier, somebody appeared.
Yes, Lordship.
Where is Mr. DP Bora?
DP Bora is in another court, Lordship.
Ask him because you keep on changing the councils. That can't happen like this.
Yes, Lordship.
You were very much present. So why it is taking such a long time?
He instructed that he has not received the instructions, Lordship.
Huh?
He has not yet received the instructions as per earlier order, Lordship.
He had not received instructions.
Seems
Okay, we
so.
set aside the suspension then.
Then Lordship may
We
take
set
it up
aside the
after Sunday.
suspension. Madam, you don't take this court very lightly.
No, no,
I want the instructions by 2 o'clock. What steps have you taken?
I'll inform him, Lordship.
And else 2:30, ask that, who is that person?
Lordship.
It seems that you have taken this court very lightly. Ask this, who has done it? The Joint Director of Health Service at 2:30, ask him to be present by video conference.
No, no, Lordship. That is, I will inform the council.
I
that
want
DP
the
Bora, Lordship.
instructions or ask this Joint Secretary to the Government of Assam Health and Family Welfare Department. He has suspended him, na?
Yes.
So ask him to be present at 2:30. Video conferencing. Okay?
Take it up after some time, Lordship.
Get your instructions. Don't take this court very lightly. Otherwise, you get a, we set aside this thing. If you have not, because the person has been kept under suspension, he has been released. If he has already been released, then what is the point? You only suspended him because he was arrested by virtue of 6(2). Now, once he is being released, you can't keep him unless you draw up disciplinary proceedings against him. You have not drawn up, and because of a case being filed, you cannot draw up disciplinary proceedings. There has to be some basis.
At 2:30, Lordship.
2 o'clock, instructions, else 2:30, person appearance. Video conferencing, okay? Tell whoever your counsel is. Yes, where is that counsel? The other one. The counsel for the Mr. D. Deka, why your information has not been disposed of till now?
Lordship, as the instruction is.
Yes, yes, your matter.
The commission is still dealing with the appeals which were filed in 2024 December. The appeals are taken up serially. So as of now, the commission is on the.
No, he filed the appeal on
In
6/8/2025.
2025. Commission is still dealing with the appeals which were filed in 2024, Lordship. And
Why? This can't be the thing. Then should we say that till we don't finish off all the matters of 2021, we won't take up motions? Tell me, is that the way?
Appeals are being taken serially, that has been.
No, serially, but is he only sitting for one matter?
No, Lordship.
Then I think it's the State Information Commission should relinquish his job and let it be more efficient people.
Lordship, the appeals.
No, Mr. Decker, tell me, is it possible for this court to say that, look here, till we don't finish up the all pending matters, no fresh motions? Then stop your state information here, or should we record it?
Lordship, because that is on instruction, they're dealing with the appeals which were filed in 2020.
Where is the instruction? Produce the written instruction. No, produce the written instructions. As to why it has not been filed, a written instruction, then we say that it is a defunct organization and as such appeals are not necessary, then they will directly come to the High Court. We don't have any problem in taking up matters. It is only because of the delay in disposal, your appeal having been filed, I have not been able to pass an order here.
Lordship, appeal has not been considered.
This can't happen. We have it on 21st.
Yes, Lord.
You get this instruction.
As to until when.
Issue notice making it returnable on 21/1/2026. Mr. D. Decker,
So number one.
the Standing Counsel of the State Information Commission, appears on behalf of the respondent number 1, Miss So-and-so. You are standing counsel. Oh, he is appear respondent number 1. You don't know your brief. Just standing counsel. Appears for respondent number 1. You are for? Are you a standing counsel? None appears for the respondent number 2 and respondent number 3 on call. Is the High Court, Guwahati High Court, short of advocates? Tell us. On the administrative side, we'll look into it. That the High Court doesn't have other standing counsels. You are nobody out there to make submissions. If you have record your submission and dispose it off, and tomorrow the High Court will say, who is she? Has the High Court given you an authority to appear? Has the High Court given you an authority to appear? Then none appears on behalf of the respondent number 2 and 3. Full stop. The petitioner herein is aggrieved by the delay in disposal of the statutory appeal filed before the State Information Commission. State Information Commission. This court inquired with Mr. D. Decker as to why the appeal, which was filed as far back as on 6/8/2025, have not yet been considered. He submits that the State Information Commission presently is only dealing with those appeals which are pending from in the month of December 2024. Full stop. This court would like the said aspect be brought by way of an affidavit to be filed on or before 21/2026 so that appropriate directions can be passed in this regard.
Lordship, will kindly-
We'll pass an order that this thing has become
Lordship, will kindly record.
infructuous.
The appeals are taken serially. As-
No serially business. The question of serially means, are you going to say that 2024 a matter we should take today? No more fresh motions?
Lordship, the appeals are taken on the hearing, it is not as in motion and.
Not hearing. What notice have been issued? Have you issued a notice out there?
No,
then-
not, they are not considered for the first time even.
Then why?
Because the appeals.
I'm not saying that you are to dispose of the appeal. I'm only asking you, what steps have you taken in that appeal? The appeal has to be, notice has to be issued asking him to provide the instruction. It is a small matter. Because of 10 rupees, you can't do it. We can very well pass an order.
It's not been attended to that.
Yes.
either.
Or say that we are not in a position to deal with it. We'll pass an order, taking into account that it is a defunct organization. Don't worry with that. Yes, what is this?
This is also regarding habitation Katma upon the left forearm. Only issue here is that they have not taken a specialist opinion before passing the rejection order lawsuit. Rejection order is at page 32. Reason for medical unfitness, hesitation customers on left forearm.
Unfit on account of examine multiple hesitation. Oh, hesitation. Oh, this one.
But no specialist opinion was taken.
Secretary.
His
We have got somebody from the secretary. He's okay.
Later on, he went to Professor Medical College, wherein the Department of Psychiatry
No
said,
PSM. So we dispose it of within this thing with a specific direction that you are given the liberty to submit a representation within 10 days. They will decide within 60 days. Chalo, hey to order AM Khan order to.
Obvious.
Then 16. Space you're also given to 57.
Is the education department there?
Yes, I'm.
Okay. Yes.
Page 49.
Now here the issue which is involved is this. Mr. I.S. Saikia's client had retired. But he was recommended. Okay. Now in the meantime he has retired, for which he has filed another petition out there saying that he should have been granted the appointment or he should be given an appointment subsequent thereto. That is one aspect. His case is he is number 3. But while doing so, some 3 marks have not been considered on the ground that he has not been some energetic or something to that effect. Isn't it? Something like that. Yes. So that is why he has challenged that recommendation which is being made. So you file your affidavit in this matter, will issue notice in both. Others case notice issued. Okay, notice has been issued now. So in this case, we issue notice, you file your affidavit within a particular period of time, and I think it matters needs to be disposed. If whether he will be entitled on the basis of the recommendation to be now given an appointment retrospectively, means he needs a notional appointment from a particular date. So on the basis of that, can it be said he has a notional promotion as a headmaster? But be that as it may, then if he gets a notional promotion, then he goes out. But his case also has to be considered as to whether the 3 marks being taken out, resulting in he becoming less than this, would have any impact. Well, issue notice making it returnable on 6th of March 2026. Mr. So-and-so accepts notice on behalf of respondent number 1, 2, 3, 4, 5. Full stop. You are joined the Burman? Mr. I.H. Sakia, the learned counsel, who is on caveat. You are a caveat also. Accepts notice on behalf of the respondent number 6. Extra copies of the writ petition be served upon them by today. Today.
Madam, regarding WPC 7486/2025, I am for the respondent number 1 to 4, madam.
No, it's okay. That I am not looking into 7486. I am saying. Here notice has been issued. Okay, no problem. It's okay. Here, you are for 1 to 5 or 4.
1 to 4, madam. 1 to 4.
Why not 5?
Madam, this is represented by school selection committee, madam. Managing committee is there, madam.
You have no role.
Yes, we have no role here.
I'll take justice service.
Okay, 1 to 4. So and so appears for respondent number 5. As regards the extra copies that are going. As regards the respondent number 5, the petitioner would take steps by way of speed post during the course of the day. By tomorrow, I think the office is open tomorrow.
Okay.
Last night.
Tomorrow.
Holiday.
Kondo, huh? Second Saturday, ni? Oh. Then you have to take it by today, huh? Today. First of, in addition to that, the petitioner is also given the liberty, shall also take steps by way of dusty upon the respondent number 5 routed through the registry of this court and file an affidavit of service on or before the next date. First, the petitioner shall ensure that the service upon the respondent number 5 by way of dusty is completed on or before 13th of February 2026. The case of the petitioner herein is that the petitioner herein is that the respondent the petitioner herein have assailed the order dated 2/11/2025 issued by the Director of Secondary Education Assam, whereby the petitioner who was earlier whereby the petitioner have not been granted any marks on leadership skills. Isn't it? And resultantly, the petitioner had secured lesser marks than the respondent number 6 and another one and one other and one Derajuddin Ahmed. Full stop. It is the case of the petitioner that this not granting of marks suffers from not only, it suffers from malice in law. Full stop. He further submits that if the petitioner would have been granted the marks as was granted earlier, you got earlier more marks, na?
17.
17. The petitioner would have been promoted to the post of principal.
The direct recruitment.
Would have been appointed, recruited to the post of the principal. The learned counsel appearing on behalf of the petitioner further submits that in the meantime, the persons who were recommended, who was recommended, that is the respondent number 6, as well as Mr. Derajuddin Ahmed, both have superannuated. The respondents herein therefore are directed to bring on record their stand by filing the affidavits on or before 25/2/2026. Liberty given to file reply on or before 5/3/2026. And you can list this matter along with so and so on 6/3/2026. Full stop. You are appearing here?
No, Your Honor, we are not made, I am not made part.
Okay, so and so. You have not filed affidavit. Mr. So and so who represents the respondents seeks for an additional opportunity to file the reply. affidavit in opposition. Taking into account the above, this court directs that the affidavit in opposition be filed on or before 25/2/2026. Liberty given to the petitioner to file reply on or before 5/3/2026. Caveat stands discharged. Heard, yeah, I say discharged.
On-time application minor, alleging non-compliance of judgment and order dated 15/7/25. That is at page 11.
Issue notice making it returnable on 11th of March 2026. Steps be taken upon the respondent, sole respondent by way of speed post during the course of the day. In addition to that, petitioner also given the liberty to take steps upon the respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner should ensure that the dusty is effected upon the respondent on or before 13th of February 2026. The case of the petitioner herein is that the respondent have not complied with, there is a willful and deliberate violation to the order dated, to the judgment dated 15/7/2025, passed in WPC number 434/2015, wherein there was a specific direction issued upon the respondent to examine the claims of the petitioner and release the amount payable to the petitioner in terms with the provisions of the MOU dated 24/1/2007, read with the award dated 11/7/1994, passed by the Learned Industrial Tribunal, Guwahati. It is the case of the petitioner that even after the period that the said impugns that the judgment dated 15/7/2025 was served upon the respondent on 15/9/2025, and till date, the respondent have not taken any action on the basis thereof. The respondent herein is directed to bring on record his stand as to why contempt proceedings should not be initiated against him.
Petitioner is not working on a fixed pay basis of performance per month.
Hmm?
They engage us on fixed pay basis.
and they were not being paid 2,000 rupees that to intermittently. Accordingly, the approach is on court of filing writ petition, claiming the minimum scale as per Upendas. Now, that during the pendency of that case, suddenly an affidavit was filed, indicating that they have been their services will be dispensed with. But we have not received, we've not been furnished with any order of dispensation, or that we are discontinuing.
How many petitioners here?
4 a day. In fact, they've admitted that there are about 3.72 lakhs of
So
areas to pay.
you, huh?
3.72 lakhs of areas to be paid, for all of them together, paid 67, and now suddenly they said we have been discontinued, that other case is still pending, paid 67 lakh will fine. From 2018-19 onwards, there are pending areas, and balance payable was 3,72,805. That too, at a rate of rupees 2,000 per month, which was not being paid on a regular basis. Now they are trying to take a stand that we have been discontinued. Though in the earlier affidavit, Lordship will find that page 69, it was filed in September 2024. No such stand was taken. But it is claimed in the subsequent affidavit that we have been discontinued from 1st March 2024.
Now, what do you want?
I'm praying for the notice in this case, and that this case be tagged with the other case.
What case?
The WPC number 4997 of 2020, which is pending before Lordship.
What is that?
That is where we had claimed the minimum scale, where this stand was taken that we have been terminated, we have been discontinued.
Huh?
Where this stand has been taken that we have been discontinued. So I'm also challenging that, saying that we have not been discontinued, we have been not issued any order.
You are still working?
Still working. We're still going there,
Huh?
We're still going there. That's what it claims.
This is a writ petition filed by you.
I mean, ask, yes.
Then why are you filing another writ petition?
Because now they have taken a stand that we have been discontinued. That is what we are challenging here. Earlier, our case was for basic pay, minimum scale. Now that is the areas they have admitted there are some areas to be paid to us, and at that was the rate of 2,000. But our claim is for the minimum scale. In that case, they filed this affidavit, stating that we have been discontinued, page 66.
Are you still working?
We say we are still going there,
Are you getting some salary?
No, nothing. Nothing is being paid to us. Even that 2,000 rupees, which was earlier being allotted to us, that was also not paid regularly. That's why this area has accumulated.
Now, what do you want?
Well, my prayer is that lots may be issued in this case, this be tagged with other case, so that both the cases get heard together.
What about Roman 1?
My pardon,
Relief at Roman 1.
Relief at Roman 1, so far as the reliefs are concerned, the Honorable Supreme Court has said,
No, when you are asking as per Upendas, that means Upendas says that no regularization.
Upendas said no regularization, but subsequently the Honorable Apex Court has said, if they're continuing, if these people are continuing, that this kind of removal during the pendency of cases, it's not proper,
Where?
Unfair level practice,
Where?
Jagu and all, the Supreme Court has said, that once the cases are pending, and people are asking for scale of pay, you discontinue them, this is unfair level practice, There are a number of judgments, Dharansi is one, Jagu is one,
So you are giving up on that?
No, not giving up, Our prayer is still
But
there.
how, don't you think both will have different connotations? Taking into account here, you are asking for regularization. In the other case, you are asking for Upendas. So how do you gel both?
Regulation can be on the minimum scale also.
Huh?
Regulation can be by giving the minimum scale.
The minimum scale is another aspect.
True.
Getting the minimum of the scale of pay is another aspect. To non-sanctioned post if you are appointed. So, but thereby, are you not accepting Upendas?
Malad, my submission would be, malad, minimum scale can be granted, malad. Even after regularization, minimum scale be granted, or malad, if they will upgrade to regularization, malad, that will be better, malad. But minimum scale is what we will initially prayed for, but since they have
So
said.
therefore, I'm saying
Malad,
there's not a dichotomy to the effect that here you are asking out here,
malad,
that kindly regularize me.
malad.
Whereas there is another petition that you say that I follow Upendas.
Well, at that point of time, my claim was because of the regular minimum
So
scale.
if I put this matter with that,
Malad.
wouldn't it be conflicting?
Well, my submission will be, minimum scale can be granted, still. malad,
Minimum scale is there. There's no quarrel with
like,
that.
if they will.
The relief as regards 2, 3 is a different aspect.
Malad.
2, 3 can be very well done, but how about 1?
Well, one malad can still be granted, malad, if malad, they consider malad, that malad, after giving minimum scale, if they want to regularize, they can always do it, malad.
Hmm?
If after giving minimum scale, because of their long continuance in service, malad, if they want, they can still be
No,
regularized.
you are challenging out here the discontinuance
Discontinuation, malad, true, malad, true.
on affidavit, although there is no verbal
No,
letter
malad,
out there.
true.
But the fact that they have duly admitted that these people were engaged
Yes, malad,
by way of an affidavit
yes. In fact, malad,
filed as on 2018, 19, 20,
yes, malad,
21 and 24,
malad.
up to the month according to the duty report.
In fact, malad, there's paragraph page 52, they have said the malad proposal also, malad, for malad, this payment, malad. So that was there, malad. So my prayer would be, malad, even after malad minimum scale, they can still be regularized, malad. It will be a higher relief, malad, better relief, but then.
The relief which you gave up earlier, now you are seeking it, whereas you were still insisting on that relief. Problem is there, na? See, if you are going and claiming still Upendas, otherwise it's okay. Without that repetition is there, it's okay. If you want relief 2 and 3, it's okay. 2 and 3 is okay, but as regards relief number 1, don't you think that there is a problem out there with that repetition pending?
Since the other two reliefs are also there, malad, that your lordship.
No, for that it's okay. So my relief, notice I'll issue only in relief 2 and 3, not for 1.
As your lordship please. Because my continuation is more important, malad, because otherwise there will be a no way.
What do you say?
This stage, malad.
One is concerned, this is an offer. For accepting vendors not.
That is what I'm saying. And he still insists on the earlier petition. If he had given up the earlier petition, it would have been different.
But so far as second and 2 and 3 is concerned, not see the second prayer, not we read in the general laws of circle, taking aside the stand of the respondents in that case. So that court will set aside the stand getting that petition law. A stand I have taken by filing in a particular case law. That can be set aside by the court in that case only. So where is the requirement of filing another petition law? Or setting aside a stand taken by a respondent in another.
But the stand has to be accepted by the court.
Yes. By the court will accept.
They say you are always at here to reply out there.
Malad,
Why do you have to file a thing?
I had replied, malad, and malad, though this is not on record, this one of the honorable court said that why didn't you file it? I made the same prayer.
But mainly on the, because one thing they duly admit that you were engaged.
Yes.
There's no quarrel with that.
Yes.
They were engaged.
Yes.
They say that we have discontinued.
Malad.
The fact that they have allowed you to continue or not, isn't it the subject matter of that petition?
True, malad. That is what I had argued, malad. But then I was told, unless you challenge it, malad, I cannot grant you relief, malad. That's not on record. But that was what I was told, malad. That's what I had argued, malad. Since it's already there.
Where the third one is concerned, it also not to be reading the measure of certificate. Setting aside uncommunicated orders, if any.
So we have not been communicating anything. That's all case, man. And the stand that we have asking for setting aside is only with regard to the alleged discontinuation, not anything else.
So you admit that you have been discontinued.
No, the stand.
No. You unless you if you are going on the stand, it's a different thing. Stand is the subject matter there, which is to be executed. So you have to accept that you have been discontinued.
Look, the difficulty is, my lord, our case is that we have not been communicated anything, my lord, except that affidavit, my lord.
So
That's
therefore the affidavit, by way of an affidavit, you cannot be discontinued.
true, my lord, true.
So therefore you have to accept that you are discontinued.
I have said that my predicament was that I was told whether
You are putting this court into more predicament, isn't it?
Because
He
that was,
accepting. The moment you are challenging, you are accepting.
well, that was.
Otherwise, you cannot challenge assumptions.
No, my lord, since they have taken, it's not an assumption, since they have taken the stand, my lord, I have to, my lord, challenge that, saying that I have, my lord, been continuing, my lord, that's what I've brought in affidavit of. In that case also, here
We
also I've
do
taken
one
the
thing.
affidavit,
We do one thing.
my lord.
I won't issue notice here now.
My lord,
I'll list this matter with that matter.
my lord, my lord.
And then let's see how we can proceed with that matter.
That would be
That is a better option.
better,
Huh?
definitely.
And then if necessary, we record it, for which you need to file it.
My lord.
Let them come up and say that we have discontinued.
That
And as I am taking this matter bench for another 6 months, I think we can regulate it. So that is the only way out. But I won't issue notice here because this will have far-reaching consequences. 1 and 2 and 3, you can't get it because it is either an assumption or you are one cannot happen.
I understand, but stop calling for lordship. That's why lordship will do take both this case. That will be my way.
List this matter again on 22nd of January 2026 along with WPC number 4997/2020.
Biplab.
But please, Lordship. Lordship, including step number 88 and 89, at that time, medical.
You don't have blood.
Lordship,
No blood. Anemia. Anemia is no blood. Your hemoglobin is 11.4.
But on the next day, Your Lordship.
But isn't it a thing which can be improved?
Lordship.
Tell me.
As
All other things are understandable.
but Lordship, on the date
But,
it was
but
low.
the fact there, unless it is a disease, but the fact that he is having a hemoglobin of 11.4, which should, for male should have been from 12 to 14, it is not.
From as per Google, it's 13.5 is the.
No, we don't go by Google. Let us go by whatever.
That is-
For male, it is around 13 to 16.
Yes, Lordship.
You could have taken some chicken soup or something, or
the next
some
day,
pomegranate juice.
On the next date, my hemoglobin was 13.6.
But it vary from hospital to hospital also. Maybe a little different. Maybe there. But on that date, it was 11.4 and review it's 11.5 after 4 days. So 0.1 maybe.
And in another one, it is different. But this can't be a case for here because where is the medical report?
This number
Yeah, Pokraja
18,
Medical
18.
College.
and 90 is the proposal.
Huh?
Is number 90 and 91.
90 is the report of the
90
hemoglobin level.
Where is the hemoglobin?
Approximately, okay.
Yeah, 13.6. It's 13 to 17.5.
Yes.
You do one thing. Same order. Submit your representation within 10 days. They will decide on that aspect. And I think that is the best order I
Yes.
can pass. For me to enter into that and they can very well take another.
But Lordship,
examination.
it may vary. If he had taken so much of good food, then it will definitely increase. If you-
Obviously. No, this hemoglobin can be very well increased. And I don't understand how can he be unfit unless he's suffering from anemia is a different aspect.
11.
Where under no circumstances it cannot exceed. But it can very well exceed by very many other aspects. Maybe he is because of you not giving him a job or he's having no job, he's not being eating well. There might be circumstances.
Yes.
But The same order, AM Khan on is that. Ali yat eta line eta less full stop. The shall submit a representation of with all these things within 10 days and shall decide. Full stop. In addition to that, this court further directs the review medical board to carry out a further test upon submission of the representation of the hemoglobin level of the petitioner.
Amlan.
20.
Petition has applied for a post of constable under Central Armed Police Force, my lord. My lord, he has qualified the written examination and physical test. But during the detailed medical examination, he was declared unfit due to left eye squint, my lord. Then after the review medical examination, he was again declared unfit, but due to right eye squint. And earlier it was left eye, then it is right eye. And after that, my lord, the petitioner went to Assam Medical College, Dibrugarh, my lord. Then it was found that there was no ocular abnormality, my lord.
Same order. Left or right eye squint. And it আগৰ নিচিনা AM Khan. Yes, Mr. Karim. How many petitioners are here? My goodness.
55.
55.
For the
And
all are same yellow sheet.
what is the same?
Recovery the risk and hardship allowance, risks and hardship allowances.
Oh, that one. I passed an order, na?
Pending yellow sheet.
I passed an order.
Lordship.
22, whenever they issue the notice, risk and hardship, more order আছে নেকি? What order দিছে? Whenever risk and hardship or দিছে, এইটো মোৰ নহয়।
তুমি কোৱা মোৰ নম্বৰ
These
কেইটা
are
নাই
all-
না মোৰ তাত।
Actually, I gave one. Risk and hardship or এটা দিছো. And I have fixed it on a particular date. Wait a second, were you
I
there?
didn't appear. Lordship.
Oh,
I will
I mean,
take-
huh?
I will consult someone else who would have appeared, Lordship. I will talk.
No, but I'll fix it on that date so that we can dispose it of, nah? I fix it on
It's
that
from
date.
CRPF,
Risk
Lordship.
and hardship, I think on the first or the second day. Fifth. এই কাবাক সুধি ল'ব এই ডেটৰ লগত পৰি পেলাই ষ্টেটো এটা আছে the next date I remember is on 11/5/2026 এইটো ডেটত ফিক্স কৰা আছে
11/5, Lordship.
Pray for some.
Stay.
May I pray for tag with all these cases?
Not these cases, my case, that case. I don't go with these cases. Yes.
This petition is filed challenging the order passed in departmental proceeding. Whereby
Challenging?
major penalty of dismissal from service has been imposed on the petitioner.
Appeal filed?
Appeal, to my information, appeal filed, but subsequently the petitioner also reminded the department as the appeal has not been disposed of. So there is no reply. At page 40, we submitted a reminder also on 12/8/2025, but we have not received any information. That's why we have approached for this honorable court. The allegation is that I allegedly demanded 2,000 rupees from a motorist for violation of the traffic rule. And on
What?
that basis, but allegation is that I demanded an amount of rupees 2,000 from a motorist who violated the traffic rule. So on that basis, my lord, the departmental proceeding was initiated, and after all, major punishment has been imposed on the
Police?
policeman.
Constable?
Yes, ma'am.
We direct them to dispose of within 2 months, and if not already disposed of, and if disposed, then within intimate to him so that he can come before this court. Adi item number কোনটো আছিল? Item number 3. 3 লগত মিলাই দিব। Disposed. JK Goswami has discussed. To dispose of within 2 months, and if it is been disposed, to intimate you, and liberty given to you to again approach this court if you are aggrieved.
If disposed, we will furnish the
You
copy.
inform him
Your
of
Lordship.
it. And this certified copy will be served upon the Director General, no? He's the appellate authority, no? Yeah.
Lordship.
খালি তাত এটা লাইন লিখিছো যে আগতে ইনষ্ট্ৰাকশ্যন লোৱা আছিল the earlier had sought for instruction if you লিখিব নালাগে এই দিয়ক মই ডিছপ'জ অফ কৰি দিছো দিয়ক ইমান কৈ থাকাতকৈ মই ডিছপ'জ অফ কৰোঁ এই আগৰটোৱে লওক আগৰ
23
এইটো দিয়ক আগৰটো দিয়ক ডিছপ'জে কৰি দিছো পটককৈ Heard Mr. S. Biswas, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Talukdar appears on
J.K. Goswami.
J.K. Goswami appears on behalf of the respondent number
All that,
1,
all that is
3. Gustav. The petitioner herein has approached this court seeking a direction, seeking a writ in the nature of certiorari to set aside the impugned order dated 7/12/2023 passed by the respondent number 3, na?
Yes, my lord.
By the respondent number
Head of police. SP, my lord.
respondent number 3.
Response number 3.
By respondent number 3, and further seeking a writ in the nature of mandamus, thereby directing the said respondents to reinstate the petitioner with all consequential benefits. From the materials on report, it is seen that the petitioner, that a departmental proceedings was initiated against the petitioner on the basis of a show cause notice dated 26/9/2023, alleging inter alia that the petitioner had taken a bribe of rupees 2,000.
Demanded, my lord.
Had demanded a bribe of rupees 2,000. Pursuant to the show cause notice, the petitioner submitted the written statement of defense, and in pursuance thereto, an inquiry report was submitted. By the inquiry officer. Opining that the petitioner, that it had been proved beyond doubt, that the petitioner had demanded rupees 2,000 had illegally demanded rupees 2,000, and he was departmentally not entrusted with any checking duty. Pursuant thereto, in pursuance thereof, a second show cause notice was issued along with the inquiry report asking the petitioner to submit a reply. The petitioner duly submitted a reply to the said show cause notice. The disciplinary authority thereupon passed an order on 7/12/2023 holding that the petitioner was guilty of misconduct alleged against him, and he was imposed the major punishment of dismissal from service. The petitioner, being aggrieved, preferred an appeal against the order dated 7/12/2023 before the respondent number 2. The appeal however, have not yet been disposed of, resulting for which the petitioner had also submitted a reminder on 12/8/2025. Full. Taking into account that the appellate authority have not exercised its jurisdiction vested upon it, the petitioner has been compelled to approach this court, challenging the order dated 7/12/2023, passed by the disciplinary authority. Full stop. This court have duly heard the learned counsels appearing on behalf of the parties. And it is the opinion of this court that as the petitioner had already preferred an appeal before the appellate authority, this court at this stage should not opine anything on merits. Rather, it would be in the interest of justice for passing an appropriate direction upon the appellate authority to dispose of the appeal as expeditiously as possible. Consequently, this court therefore disposes of the instant writ petition with the direction upon the respondent number 2 to dispose of the appeal as expeditiously as possible and not later than 2 months from the date a certified copy of this order is served upon the respondent number 2. For the sake of clarity, this court further finds it pertinent to observe that in the circumstance, the appeal filed by the petitioner have already been disposed of, the respondent number 2 is further directed to forthwith intimate the petitioner about the order so passed in the appeal proceedings. Number 3. This court further observes that in the circumstance the petitioner is aggrieved by the order passed in appeal, the petitioner would have liberty to again approach this court. Instead of telling him so much, the order is much shorter. Yes, Miss S.G. Bulwa. What is this matter about? Initial pay. Consider the case of the petitioner and refix the initial pay of the petitioner as per the provisions of ROP 1990 with all consequential benefits. Why have you woken up so early? Why in 2026? You are asking that your pay should be from 1990. I think that was the 5th pay commission. We are in this I think the state have already declared the 8th pay commission. The 3 pay commission means a decade, not 1, not 2, 3 decades is over. Now why should I issue notice?
Maybe please to peruse page 60. May I lordship maybe please to peruse page 67. My lordship is second round.
Page?
67 and the relevant also 69, my lordship. My lordship, here I have declared a bundle of repetitions were filed, my lordship, and I was amongst one of them, my lordship. Would page 69.
What is your case?
My lordship, petitioner is an A&M nurse, my lordship. She is an A&M nurse, my lordship. So my lordship, she has been serving presently, she's posted in our high court itself. My lordship, whatever was that she was other similarly situated persons from other departments were getting the benefit of the ROP rules, my lordship. So here in the case of the petitioner was that the petitioner similarly situated persons was that the benefit with regard to ROP rules were not granted to the ANM nurses, my lordship.
This person has earlier filed a writ petition.
Yes, lordship.
Now what happened?
So no other pass with that regard, and they with the period with regard to the contempt was also over. So my lordship, I have to come with regard to second round of litigation, my lordship. The direction was stated in that repetition, it was not directed to pay, but to revisit the matter to see whether I am entitled or not. With regards to revisit the matter was the direction, and the same was not done. And during the phase, they were on an impression that the same would be done, and in between the period with regard to the contempt was also
Same was rejected or not?
given to them, and as per their knowledge, nothing was revisited, my lordship.
The period was not fixed
No, it was fixed 2 months. My
Huh?
lordship. It was fixed.
within 2 months. Then isn't it a case of contempt?
Case of contempt, direction was there. My lordship, the
If they don't do it, it's a different aspect.
order was passed on 25/10/2024, and it was within 12/2024, my lordship, 2 months ago, and so she has not applied for contempt within the phase, so I took.
When did you serve the copy of the order?
My lordship, the.
6/11. Oh, the 6/11, it will still you have time. 2 months, 6/1. Then only the 2 months will expire. Take this here, but this is not a case of the notice that you are again re-agitating the same thing which has been disposed of, isn't it, Mr. Naik? You are the person who appeared. Huh? Yeah. No, it has not, because you see,
2 months.
it is said that within 2 months from the date on which service of the certified copy. Service of the certified copy was on 6/11. So 6/11 means 2 months will expire when? 6/1,
My lordship, to.
6/1, 2025.
Fine.
So here
In that
is
case,
still time.
My lordship, I have made a fair submission with that regard. My lordship, what happened was that the petitioner, my lordship, while serving the copies, my lordship, only with regard to the AG, the copy she kept in her hand, the other copies she served to the department has not kept any copy with her, my lordship.
AG has kept it. But
Yes.
tell me, I can give you an extension
My lordship,
for revisiting.
my lordship,
But I cannot give any further direction of what you are asking.
because my lordship, I was granted, my lordship, while serving the copies also to file a contempt. My lordship, I have to make a party with regard. She has kept with regard to the AG.
Okay, we do one thing, we'll issue notice and ask them what the steps they have taken pursuant to the order. That's, I think that is the fair thing. But I can't look into that.
Yes, my lordship.
I've observed that. I am not going to look into those aspects. Issue notice making it returnable. Madam, you will get your information by 4th of February.
Not.
Issue notice returnable on 4/2/2025-26. Miss
Yes, sir, ma'am. For health department.
Mr. P. Naik, the learned additional additional advocate general accepts on notice on behalf of the respondent number 2. Ms. S. Sharma accepts notice on behalf of the respondent numbers 1, 3 and 1 and
1
3.
and 3, Lord.
And Mr. R.K. Talukdar accepts notice on behalf of the respondent number 4. Extra copies of the writ petition be furnished upon the learned counsels during the course of the day. Full stop. The case of the petitioner herein is that the order that in spite of the judgment passed by this court on 25/10/2024 in WPC number 3898 the case of the petitioner herein is that the petitioner herein has approached this court seeking a direction upon the respondents to consider the case of the petitioner and to refix the initial pay of the petitioner as per the provisions of the ROP rules 1990 and grant all the such benefits along with all consequential benefits, including areas. Full stop. It is relevant to take note of that the petitioner earlier had approached this court by filing a writ petition being WPC number 3898/2024. Full stop. The learned coordinate bench of this court had disposed of the said writ petition with the following directions, which is with certain directions. Paragraph 11 and 12 of the order dated 25/10/2024 being relevant is reproduced hereunder. Full stop. The counsel appearing on behalf of the respondents 1 and 3, 1, 3 and 1 and 3 is directed to apprise this court on the next day as to what steps have been taken pursuant to the said directions passed by the learned coordinate bench of this court in the order dated 25/10/2024 in WPC number 3898/2024.
Thank you. Thank you for.
What is this? Fill up vacant Anganwadi workers, assistants, positions in the Anganwadi centers. And petitioner must have applied. Petitioner applied. Then what happened?
Interview has been held, my lord. Thereafter, result was not declared, my lord.
What do you want now?
Only the result, my lord.
Oh. But you are making a lot of prayers.
Subsequent prayer, my lord. Just want to make a appointment in the post, my lord. After the result, that process will.
Okay, you just get the instruction as to whether the results and when the results would be.
Lots.
Okay. Issue notice making it returnable on 6th of February 2026. Mr. J.K. Goswami accepts notice on behalf of the respondent numbers 1,
all the
2, 3, 7, all the respondents. Full stop. Extra copies of the writ petition be furnished upon him during the course of the day. The case of the petitioner herein is that in pursuance to an advertisement dated 1/10/2024 for appointment of for filling up the post of Anganwadi worker assistant positions in the Anganwadi centers, the petitioner applied applied on 4/10/2024. The sole grievance of the petitioner. No. The learned counsel appearing on behalf of the petitioner submits that though there are various reliefs have been sought for, but the sole grievance of the petitioner herein is the non-publishing of the results, and as such, the petitioner has approached this court. Mr. J.K. Goswami appearing on behalf of the respondents shall apprise this court on the next date without fail as to why no results have been announced in pursuance to the advertisement dated 1/10/2024. And if the results have in the meantime been announced, the said results be placed before this court on the next date. Yes.
This writ has been filed, my lord, against the order passed on 9/8, my lord, by the 9/9 lordship.
What has happened? You are Gaubra?
Selection appointment of Gaubra of the day. Now, my lord, here, my lord, the basic qualification is the SSLC, my lord. But the selection committee did not assign any mark for the SSLC. Rather, they have assigned mark for the higher secondary, BA and MA, my lord. Since I am a matriculate, my lord, therefore I no mark was assigned to me in the selection process, my lord. What is the basic qualification of SSLC only, my lord? The rest are the higher qualification. But no mark is assigned for the SSLC qualification, my lord. That's why I deprived my lord. Some marks should have been given for the SSLC also, my lord. Since only the basic qualification SSLC as per requirement.
Where? What is your name?
DP Sultana, my lord.
DP Sultana Begum.
Yes, my lord, look into page, and annex page 63, lord. This is the score sheet, my lord.
They are giving marks for HS,
HS
degree,
and
master degree.
but not for SSLC. no.
Why, what is there to give you marks?
SSLC is a basic qualification.
So then also they will make it to 1, 2, 3, 4 and 5. 4. Then also you don't get it. You see, you lose out because of 1 mark.
Yes, my lord.
Let us assume, kindly come to page 63.
Lordship.
1 mark is given here.
Yes, my lord.
They can't give you more than that. They'll give you 1 mark only.
4%, 4 marks then.
Understood. That is 1 mark can be given to you, not
Yes.
more than that. Isn't it?
There is 4% in the selection committee.
Mr. Ghosh, kindly understand. He may give you 1 mark for HSLC.
Yes.
If HSLC is 1 mark, then HS will be 2 marks. Degree will be 3 marks. Master degree will be 4 marks. Then also you lose out.
Well, that has not been done, my lord. That has not been done by the selection committee, my lord.
And anyways, what is this? Another one? Why there are 3 different?
Because there is a 4 member in the selection committee.
Huh?
4 member.
All have given different marks.
No, my lord. Actually, none of them given me any marks, my lord. So far.
No, all of them have given different marks.
Yes. Two.
But you can't surpass the number 9. He has got 43.
And my lord, so far the Gabuda is concerned, they say 2 marks should be assigned. 2 marks, my lord. But
What?
they have given me 1 marks, my lord. There is nothing. 2 marks. Lordship will say claim of the relative of 2 marks. But they
Where?
have given 1 mark.
No, one has given 1 mark, the other has
No,
given,
no,
everybody
my
has
lord,
given
say
1 mark.
Lordship will say 1.
Then? So let us assume 1 mark is given. Then also you don't get anywhere.
448, my lord.
What 448? You are going to get 8. It is divided again by 4.
And my lord, the composition of the selection committee is also wrong. Also illegal, my lord.
What?
Because it should be comprised of 3 persons only, my lord. As per executive instruction, my lord. No notification, nothing was issued. No, how the mark will be assigned, that will also not be notified, my lord. We received only through RTI, my lord. Nothing, no. Now, my lord, in order, lordship will say, he has made a hypothetical calculation to my lord reject our appeal. Lordship make, I will see page 90.
Where is the appointment order?
Appointment order, there's page, my lord.
You have filed an appeal also?
Yes,
my lord.
appeal rejected, my lord.
I'm against that.
Appeal,
Against that appeal.
appeal is rejected, but their debate is their alternative debate. Others, one of the executors of 162D
To be fair to the-
and go for review, my lord.
He was not awarded the provincial mark for allowing. Differential. The mark sheet clearly shows the appellant was awarded 1 mark out of 2 under the relative of fluences. By each, and thus total 4 marks was allotted to the appellants in the line with the review provided by the mother. 2 marks for direct hires like in law. You are relative.
My lord.
You are not son and daughter. Are you son and daughter or not?
Daughter-in-law. Daughter-in-law.
Daughter-in-law.
Yeah.
Daughter-in-law won't get it. Son and daughter. Respondent number 5 being a relative received 0 marks in the category. However, total the interview score respondent number 5 was 43, surpassing the Iman. Appellant Iman. The post of Brahmapuran is not hereditary and suitability and Iman. Regarding the non-consent of family preferred, the Supreme Court issue and so expensive political party members. However, it's stated in that the present prohibit membership in a political alleged active BJP involvement by the respondent number 5. However, the resignation letter is the reflecting circle of the report verifying the resignation in the same way. Political party was selected inclusion of additional members beyond the 4 members is enhanced diverse experience. Was initially notified to the system. I remember. This reduction in the number. However, immediate. Assess whether the presence of the program is impacts. The reduction.
Yes.
Bad case.
My lord, then third ground is there, he belongs to a political party, my lord. Which
Who?
makes him eligible, the person who has selected, my lord.
No, he does not.
Yes.
No.
Lordship may kindly look into page 68.
Now here's where you see, resignation letter dated 11/3/2000, the acceptance thereof, circle officers report dated 2/6/2000, verifying the resignation is genuine, and villager statement confirmed respondent severed all political ties.
Now, Lordship may kindly page 69 then. Page
I'm seeing page 90.
69 Assamese. 69, my lord, that is the, we have enclosed the document to belie his
He has
statement.
resigned.
Yes,
No case.
page 69.
No case. I think dismiss. No.
Page 69, Lordship may.
Heard Mr. S.K. Ghosh, the learned counsel, appearing on behalf of the petitioner. Mr.
For Lordship, may I make to review, my lord, if there is a provision for review. Review, there is a provision for review, my lord.
Will you file review?
While deciding the lordship dismissed, he come to the review. In the first instance, I pointed out that there is a provision for review.
163.
Why he did not 163?
I know that. But I thought that let me finish it here itself, today itself. Huh?
Provision, similar matter, my lord, we have also similar.
What?
Review.
Then why are you here? You want to file review, go and file review. I don't think you can do all this. But otherwise, the order is very nicely drafted. One has to say the appellate order is really well drafted. Don't you think so?
Aspect has not been considered.
Properly, page 90. Beautifully drafted.
My lord, if you lost.
Kindly see page 90. Very well drafted. Don't you think, Mr. Dutta? The appellate order is very well drafted. I've seen there are a lot of judicial officers may not be in a position to draft in this manner.
Page 69, lord.
Very well made. Even he is referred to it's like a judgment. Means I think it's proper judgment. So what do you want? Dismiss.
My lord,
Let us finish.
Page 69, lord.
You go again. You have to come before this court. Again, I'll dismiss. Then you have to go to the division bench. Then to Supreme Court.
Page 8, lord.
Which one?
6
So you want one more. 163. Okay, I heard Mr. S.K. Ghosh, the learned counsel, B.K. Ghosh, the learned counsel, appearing on behalf of the petitioner. Mr. T. Suti appears on behalf of the
T4, 5, and 6.
respondent state, and Mr. S.C. Dutta appears on behalf of the Revenue and Disaster Management Department of the Government of Assam. Mr. B.J. Ghosh, the learned counsel, appearing on behalf of the petitioner, submits that that taking into account that various factual aspects are to be dealt with, have not been properly dealt with, the petitioner, instead of pursuing the present proceeding, would like to withdraw the instant petition with the liberty to approach the review and with the liberty to file a review against the order dated 9/9/2025 passed by the Office of the Director of Land Records and Surveys, etc., Assam, against the speaking order dated 9/9/2025 in terms with Regulation 162 capital D of the Assam Land and Regulations 1886. Taking into account the said submission, this court therefore closes the instant writ petition on withdrawal. However, the withdrawal of the instant petition shall not preclude the petitioner to prefer a review against the speaking order dated 9/9/2025 if so advised.
Well, only delay may be there, my lord. That may be taken into consideration since we are not changing the because 90 days.
Delay? I've given that permission. But you see, how do I condone the delay?
So they have to.
They will condone it. How can I give it? And if it is not there, then again you come back, I'll dismiss it. I'm here. Yes. What is the matter about? No lawyer's name. What is this case? What is the matter, madam? Direct command to the respondent to make an inquiry into the matter and take a decision removing the respondent from the board member of the. This is a bench 4 matter, na? Can it be bench 5?
Yes.
Huh? Ward member of ward
member-
number 7 of so and so Gaon Panchayat.
Bench 5 meter,
Bench 4.
bench,
Gaon Panchayat is bench 4.
bench 4.
Okay. None appears on behalf of the petitioner on call. Full stop. It appears that the instant writ petition is a bench 4 matter. The registry shall verify and thereupon list the matter before the appropriate court.
29.
The petitioner was serving as ANM non-fellows. He was appointed in he got repairs on 24. However, no financial benefit was granted to her. She was entitled to.
You resigned?
The APR 24.
So you want the MACP?
Yes, madam. But
Hello? You issue notice?
Notice law.
Issue notice making it returnable on 11th of March 2026. Ms. Deborah, you are appearing, Mr.
Yes.
Mr. P. Naik, the learned additional advocate general accepts notice on appears on behalf of respondent number 2 and 6. Ms. So and so
1, 3, 4, and
appears on
7.
behalf of respondent numbers 1, 3, 4, and 7. Mr. R.K. Talukdar accepts notice on behalf of the respondent number 5. The case of the petitioner herein is that though the petitioner had superannuated and his pension has also been granted to the petitioner, but while finalization of the pension, the petitioners, the benefit to which the petitioner is entitled to under the Modified Assured Career Progression Scheme 2017 have not been provided. It is under such circumstances the petitioner has approached this court. The respondents, more particularly the respondent number 3, 4,
And 7.
7, as well as the respond number 5 are directed to apprise this court on the next date without fail as to whether the benefits under the modified assured career progression scheme 2017 have been provided to the petitioner while calculating her pension.
Yes. But
Mr. Das, tell me.
There was the advertisement, madam. Office will find the advertisement at page 23.
Page? Advertisement at page?
At page 23. It's a lot.
Some direct recruitment for analogous post of 3. Oh, this type of motion I've given a permission today.
yes, madam, at 2.
At two, na? Two motions.
Yes.
One is his and somebody else has also mentioned today. Somebody else. I've given two permissions. We take it up together.
But my case is different.
Okay.
I'm not physically handicapped, quota, madam.
But that is also physically handicapped.
Medical board, madam. Exam.
Ah, same physically handicapped. So, and there is another matter by Miss R.S. Chaudhary.
Yes.
That is also 3 matters.
Yes, madam.
You have been. So let us take up together all 3. Huh? Let me not dictate the same order 3 times. Okay. I think it should rise now.
I think item 13.
My lord, the suspension order has been reviewed, my lord, on 18/12/2025.
That is one thing. Secondly, what has happened to the charge sheet?
Third sheet, my lord, we are on the departmental side, my lord. Third sheet, I am not aware, my lord.
Okay, memorandum of charges.
The DP probably has not initiated yet, my lord.
Then how do you take care of it?
That, my lord, I have to obtain instruction, my lord. Because, my lord, regarding.
No, you have to give him a DP, memorandum of charge. Otherwise, Ajay Chaudhary's judgment comes in.
No, my lord, Ajay Chaudhary says if it has been reviewed within a period of 3
No,
months.
he doesn't say so.
It is beyond 3 months. 1812 is beyond 3. And my friend says it's the 1812, beyond 3 months. I was arrested on 11/9.
See Ajay Chaudhary, paragraph 21. You still have time, taking into account that he was released on 23/10.
Yes, my lord.
So you give him the memorandum of charge
Yes, my lord.
by reopening. Give him the memorandum of charge.
Yes, my lord.
Hmm.
Yes,
Because that is, once you do that, I have nothing to do.
yes, my lord.
But you have to do that.
Yes,
Because
my
the law is very clear on
Yes,
that.
my lord, I understand.
And this is one judgment because Ajay Chaudhary does not take into account deemed suspension.
Yes, my lord.
But there is one judgment given by me, I think some Rekibul something. What is the name?
Two division bench judgments are there by this court, where it says for deemed suspension also eligibility will come into effect. One is Rekibuddin, 2022 JLR 621, and another state went for an appeal against Ajit Sonowal,
2023, 6 GLT 115.
No, they don't, there's no quarrel with that. But when the period of 3 months will start?
From the, because with the retrospective effect, they are giving from the date of arrest.
No, the 3 months will start when you come out and inform the
Inform
authorities.
when-
They'll look here, you have been
Yes.
out.
Yes, sir.
And we have informed them through our representation.
No, are you going to say that the charge sheet is to be given inside when you are in jail?
No,
Then
sir. I have informed them, my lord,
you got the bail on 2310.
23 days.
So 2310, they still have time. Till 23-1, they have time. But from the date of the information being given, when you have been
Yes,
out,
my lord.
when did you inform?
My lord,
It
therefore,
came
revocation was
on 3/12,
3/12.
3/12, 2020.
312 they informed
Yes, my lord.
that you are out.
My lord,
So then, this is prematured. We dismiss your petition. Liberty given to you later on to come. And you also need to challenge this also.
my lord.
But you need to give this.
Yes, my lord.
312 you informed.
My lord.
Yes,
And then there's no way out. No notice out there. What is that judgment? I forgot the name. Because you see, Ajay Chaudhary says about, yes, there's no quarrel.
My lord.
Quarrel is, the thing is, Ajay Chaudhary says 3 months.
3 months. From which
No,
date?
from which date?
Date is from the date of information.
From the date of the information. From the date of the information, because otherwise the disciplinary authority cannot be deemed to be sitting just outside the jail and see,
Yeah.
oh, he has been released.
This release. My lord, the date of the pro.
So we close this petition on that basis.
Well.
Well, what is the name of the judgment? I forgot. I delivered it. Rafed Ali. I say, now the question therefore arises as to when the aforementioned conditions can be taken into consideration by the appointing authority. In the opinion of the condition above noted can only be taken into consideration when they're dealing with it. Brings the fact that he or she has been released on bail or otherwise not in any custody or imprisonment to the appointing authority who has the power to vacate the suspension order. Heard Mr. P.K. Roy Chaudhary, the learned counsel, appearing on behalf of the petitioner, and Mr. D.P. Bora, the learned standing counsel, appearing on behalf of the respondents. Full stop. The instant writ petition has been filed by the petitioner challenging the notification dated 11/12/2025, whereby the petitioner was put under suspension with effect from the date on which the petitioner was arrested, that is on 15/9/2025. Full stop. It is seen from the records that the petitioner was arrested in connection with Gwalpara PS case number 175/2025, registered under sections 318/4/336/3/340/2/3 bracket 5 of the BNS 2023 read with section 7/13 of the Prevention of Corruption Act 1988 তার আগতে BNS to full form লিখি দিব full stop. The petitioner thereupon was granted bail by this court in bail application number 3274/2025 by an order dated 23/10/2025. The materials on record show that on 3/12/2025, the petitioner duly intimated the appointing authority that the petitioner has been released on bail on the basis of the order dated 23/10/2025 passed in BA number 3274/2025. In this regard, this court finds it relevant to take note of the judgment of this court in the case of Rafed Ali Ahmed versus State of Assam, wherein this court categorically observed that a period of 3 months for the purpose of serving the memorandum of charge upon the petitioner, upon a delinquent who have been a delinquent officer who was arrested, would start from the date the delinquent officer brings the fact that he or she has been released on bail or otherwise not in any custody or imprisonment to the notice of the appointing authority. In the instant case, it is the materials on record categorically show that though the petitioner was granted the bail on 23/10/2025, but the petitioner intimated the appointing authority only on 3/12/2025. This court further takes note of that in the meantime, on 18/12/2025, the appointing authority had, by the notification, have extended the suspension for a further period of 3 months with effect from 11/12/2025. The said notification was produced by Mr. D.P. Bora, the learned standing counsel of the respondents, which is kept on record and marked with the letter X. A copy of the said notification has also been provided to Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioners. Taking into account the above, as the period of 3 months have not elapsed from the date the petitioner had duly intimated his appointing authority that he has been released on bail and or not released on bail or otherwise not in any custody or imprisonment, the instant writ petition is prematured and accordingly the same stands dismissed. Before parting with the record, however, this court finds it pertinent to observe that in the circumstance, the respondent's authorities do not serve the memorandum of charges within a period of 3 months from 3/12/2025, the petitioner would have liberty to again approach this court.
Challenge that order, 1812.
You can challenge it. They have not said anything. I have
Oblige.
given you everything out there. And that বাকি দুখন আহিছে নেকি? Unlisted? Unlisted? কাৰটো আহিছে? হ'ব সেইটো আহিলে। Yes.
Malab, wait, please, Malab, Lordship may kindly come to the page 23.
Yes, madam, your matter is also here. Yes,
Lordship may kindly come to page 23, next one.
23.
23 months.
Yes.
The government of Assam have submitted advertisement for filling up 7,600 number of vacancies. But I being a physically handicapped with 40% disability, I applied for category 1-4. Hereafter, madam, I was called for a written test. And madam, Lordship may kindly also peruse the Annexa 3 at page 28. Page 28, madam, Annexa 3. My certificate of disability certificate. But clause C. She has 40% permanent disability. But the word used is very permanent.
Huh?
The word used in this certificate is permanent disability. Madam. And to the Lordship may come to the next page, madam. The I-card issued. Here also, madam, the date of issuance has been written as 19/5/2023.
Then
Lead up to permanent, madam.
next.
Next, madam, Lordship may come to page 30, and next 5, madam. The admit card was issued under this roll number, madam. 11002348. As per this, call letter, madam, I appeared in written test. I did well, madam. Hereafter, madam, they call me for computer test. Possible. I did at page 32. This admit card was issued. Here also, madam, I have selected, madam. Hereafter, madam, they published an original select list at page 33. Lordship will find, madam, my name is Dasmin Begum. Original list, madam. Here, madam, down, madam, note. There are 3 conditions. They have mentioned that in case of PWDH.
Where?
Madam,
Page?
Page 33.
Yes.
33 is the original list select, published by the government, madam. My name is Jasmine Begum. Down below in the note, there are 3 conditions. Given, madam. And madam, the last paragraph, in case of physically benchmark disability category appointment shall be confirmed after medical examination. And he has received from medical board constituted for the purpose.
Then
Madam, I was given a department, a Lordship will find it on page 34.
before that, page 24.
Page 24, selection at serial number 6.
Yes.
There is a clause. Disability certificate. In
The
case-
shortlisted candidates will have to bring all the original testimonials, so and so, so and so, so and so, disability certificate in the case of PW,
Yes, madam.
BD candidates, and so and so. Okay, then
For verification, madam, only for verification, not for sitting in the medical examination, madam.
shall be
There are
declared in
people of-
due course in the website of Assam government, so and so. The confirmation of appointment shall be subject to verification of all academics, category 1, including ex-servicemen. But what do you mean by PWBD?
Physically,
Person with benchmark,
that's for disability, madam.
person with benchmark disability.
40% and above is called benchmark disability. It's defined under the act.
So who decides this benchmark?
The duly constituted medical board.
The board who issued the certificate.
Okay.
In my case, madam, Lordship, I have shown your Lordship. Madam,
How do we find out that PWD means that? BD?
Section, you also kindly come to the definitions of the act, section 2.
Person with benchmark disability.
I will just take your lordship to the relevant clause. Section 2E. is
Where is
the-
it? Both of you are holding one book. Give one book to me. Ah. Yes, two.
2E is the certifying authority. The question which your lordship have asked, who is the certifying authority?
Certifying authority means.
Authority designated under subsection 1 of section 57. We'll just go to that, but before that, you also will kindly come to 2R.
2R.
2R, persons with bench.
Means a person with
Not
not
less than
less than 40% of specified disability where specified disability has not been defined in measurable terms and includes a person with disability where specified disability has been defined in measurable terms as certified by the certifying authority. Now, who is the certifying authority?
57, we can come to section 57 now. Designation of certifying authorities. That's what got it. The appropriate government shall designate persons having requisite qualifications and experience as the certifying authorities who shall be competent to issue the certificate of disability. Now, if you also will kindly take up my writ petition. For a moment, I will demonstrate with by way of a notification who has been designated as the certifying authority in the state of Assam. I have annexed that notification. Your Lordships. And in section 58 is the procedure which has been laid down.
Where is that, your notification?
Number 53 is the typed copy and 54 is the original, Your Lordships.
In pursuance to the next.
53 Annexure M.
The joint director of health or respective health certifying authority in the. Director of services that we have support. Okay, the institution.
So in each district, you also find that's the joint director of health services, who will be the certifying authority for disabilities. The certifying authority shall follow the procedure for certification as laid down under section 58, 1, 2, and 3 of the said act and relevant provisions of the rules thereafter. Lots of important.
So your certificate at Annexure 3 is being issued by the Joint Director of Health Service. So this certificate, and she must be also having a similar thing. Okay.
Mine is also a permanent one, Your Lordships.
Huh?
Mine is also permanent. That category.
Okay,
yes.
whatever may be.
Yes.
Now, this is a certificate being issued. So this is a certificate which is binding till it is revoked, I suppose.
53 says for revocation, madam. 52, madam, sorry, 52. Revocation of the registration.
That is revocation and 58(3).
The certificate of the issued earlier shall be valid across the country.
Correct.
So therefore, this certificate has to be taken into consideration and there cannot be unless that certificate is not.
Unless it is reassessed by that same certifying authority, because when the disability is not permanent, then the incumbent is required to go back to the certifying authority after every 5 years for a reassessment. So unless and until it is reassessed and re-notified by the certifying authority, this certificate remains valid.
No, but if it is mentioned as permanent disability and it is later on found that there is something wrong with it, what is the course of action available?
Then your lordship, 52 in that is revocation of the If you're also talking about.
They will revoke it, man.
The competent attorney may, if it has reasons with that a holder of a certificate of registration. No, no. The 52 is for different, I think.
Be committed or cause to be committed any breach of rule or any condition. subject to
Even
this
otherwise,
certificate
no
was
person
granted.
shall establish or maintain any institution for persons with. No, this is a different registration of institutions for persons. So this is different. So how do you cancel if it is just, for example, it's a fake certificate?
In any case, a competent authority has to declare that this certificate earlier issued.
Who will declare?
The same competent authority as.
No. There it has to be somewhere something. Any person aggrieved with the decision of the certifying authority may appeal against the decision within such time and in such manner as may be prescribed by the state government to such appeal. This is an appeal. Now, just for example, let us assume that the certificate has been taken as a fake, although I'm not saying so, but for that it will help me in formulating, because your case appears to be that both of you have been given a 40% above 40% or above disability, so you fall within person with benchmark disability and in terms with section 2R. You have been issued certificate and the certifying authority happens to be the Joint Director of Health Service, and in both of the cases the certificate has been issued. Now, if a certificate has been issued, means otherwise it is binding in view of section 58(3).
58(2)B is your lordship's answer. 58(2)B.
2B.
This is the procedure for certification.
Now, on receipt of an application under 1, the certifying authority shall assess the disability in accordance with the relevant guidelines notified under him and shall, after such assessment as the case may be, issue certificate, inform him in writing that he has no specified disability. No, this is a different thing. I'm not on that. This is on the basis of an application. Now, just for example, if it is found that the certificate has been obtained fake, taking into account the we have a lot of problems with the Joint Director of Health Services earlier when lots of matters were going on. So let us assume that he has issued this certificate wrongly. Then what happened?
Lordships, there seems to be no particular, to my knowledge, there is no particular section which deals with the cancellation of a
Then
certificate.
how do you cancel a
It can
certificate?
be revoked.
How?
In section 52.
No, 52 is for registration. Both of you are not prepared.
It's a revocation of.
Yes, Mr. B. Gogoi.
But in my case, madam, just a moment.
I have understood. I will.
40% has been reduced to 15%.
Huh?
In my case, 40% disability has been reduced to 15%.
That I know. That is the reason why I'm asking that particular question. You see, a person who issues the certificate as per the general clauses of Act, it is he who has the power to revoke. But how do if the power of revoke is not given out here, then how do you do it? Just for example, it's a fake certificate. How do you take care of it? I'm asking you.
So far as the certificate is concerned, my lord, with the help of the certificate or under the authority of the certificate, he can apply for this particular post under that particular category. Now, my lord, there is a office memorandum of the government of Assam following, my lord, one OM of the Personnel Department of Central Government. That, my lord, if a person under this particular category is selected, he will have to undergo a medical test under a specially constituted medical board. Only thereafter, based on the report, if it says that, my lord, it is 40% or above, only then he will be given the appointment. Here, that's why, my lord, in page 33, in this provisional selection list, in note number 2, it has been categorically mentioned that you will have to appear. Since you are now within the zone of consideration for selection, you will have to appear before the board. Now, while examining, well, the petition, it has been found that he is only 15%, not 40.
Now, what happens to that certificate?
Certificate, my lord, probably it will have to be, my lord, cancelled, my lord, by the
So
government
without the
now.
cancellation, therefore my specific question to them was, without the cancellation of the certificate, wouldn't it be binding upon all, taking into account section 58(3)? My question therefore is that.
But my lord, in this regard, my lord, series of writ petitions have already been, my lord, disposed of. In one of the cases, this honorable court held that, my lord, even though it is not there in the act, that same argument was made in that case also. Now it is lying probably before the division bench. That, my lord, if the results comes out by a specially medical board, constituted medical board, then, my lord, of course, it will have to be taken into consideration, because, my lord, it has been found in the present case. If it is found to be 15%, then, my lord, that cannot be ignored. So no merit was found, my lord, and it was dismissed. Against that, they went to the division bench. Division bench says that whatever grounds they are taking, it is a ground for review. Review was filed. Review has been dismissed. Now it is lying before the division bench on this particular ground. And in another batch of writ petition recently in court number 7, series was disposed of, directing us to, my lord, reconstitute the board and to examine the petitioners again, along with the records that was, my lord, that is there in the district authorities, as to what procedure they have followed, what were the medical
that means
reports.
therefore
Yes.
the question is, how do you take care of that certificate?
Yes, certificate, my lord, that part will have to be.
Because
my
that
lord,
is a
some
very
step will have to be
important
taken,
thing.
my lord.
Now, I can exercise a power
My lord.
directing you to again review a certificate, unless this act gives the power. You may take very well the benefit of section 21 of the General Clauses Act and say that if I have the power to issue, I have the power to revoke.
No, no.
But that requires an inquiry. And if the power to issue is given only to the Joint Director of Health Service, the power to revoke will also be him.
That's it.
And how do you do it? Because if I pass an order which you are saying out there, first of all, if you remember, yesterday I was taking a case pertaining to special public prosecutor or something.
Yes.
In that advertisement, it has been categorically mentioned, apart from that,
Yes.
that a person with this benchmark disability, if he is there, then also he has to satisfy and be there in the medical board and do all these things.
That's it.
Then only it will be, because that becomes a part of the advertisement.
My lord.
But here the advertisement is silent on that. That is the reason why I'm putting it.
Absolutely.
But, my lord, here one thing, my lord, one in that regard,
That I have taken in.
may I reply to that, my lord? Here, my lord, this particular provisional select list was published much before, my lord. There this note 2, it is categorically mentioned. Following this, my lord, when the notice was issued that they will have to appear before the board, without any demur, they appear. Now, when the results are, my lord, against them, whether they can now turn around, just to challenge this, they should have, my lord, come at the very threshold, this making this argument, my lord, that under the act, they cannot be made to undergo a fresh, my lord, examination after having the certificate from the competent authority. They, my lord, willingly they appear. Now, when it has been found that they are below 40%, entire objective of the government is that, my lord, this should go to the appropriate person. It's not that
But without cancelling the certificate.
that part, of course, my
Because
lord.
this, by the certificate gets a statutory recognition
My lord.
by virtue of section 58(3).
No, here, my lord,
Health
yes.
authority.
But one thing, my lord, may I point out, my lord, so far as the
So
provisions
therefore,
of the act are concerned.
I would not be wrong. They're saying that some problem is there with the Joint Director of Health Service.
Yeah. My lord, so far as, my lord, Disability Act is concerned, my lord, appointment will come only when it is 40 or above 40, as per, my lord, section 34. Reservation is there, my lord, section 34. But, my lord, there are other benefits, my lord. That's why it cannot be cancelled. That will be my argument. Because there are other benefits. There are various cards that are given. What will be the category of cards? It is mentioned in the act. Though they will get other benefits.
No. But that
Moment it is
certificate, the certificate categorically mentions 40%.
But that will have to be, yes, that will have to be modified or cancelled or
By
whatever.
whom?
But same authority probably, my lord.
No, therefore, unless the Act says,
Yes.
because there is only an appeal provided under 59.
Also, you'll have to see the rules also, my lord.
Let us see the rules. If there is anything.
17 and 18 talk about the certificate of disability. And rule 18.3.1. If you also will pick up rule 18.3.1 for a moment. This is the certificate which has been issued to the petitioner, which was an unappearing and minor penal hearing. Where permanent, it is a permanent disability certificate.
Well, you see, Rule 19. Person to whom the certificate is issued under Rule 18 shall be entitled to apply for facilities, concessions, and benefits admissible for a person with disabilities under the scheme of the government and non-governmental organization funded by the government. The certificate of disability issued under the persons of Iman shall continue to valid after the commencement of the act for the period specified therein. Now, if it is a permanent, then there is nothing.
No,
Then
my lord,
how
what I am
do you-
saying is, no,
how-
that's why I said, my lord, cannot be cancelled, my lord. I'm just considering the provision I am saying. Lordship will see, my lord, he will be entitled for the benefits under various schemes, concessions and other things, my lord. Even if it is 15%, he will be entitled for those benefits. But for appointment, it will have to be 40%.
Understood, but how do you take care of that certificate? Till the certificate remains, can you do anything?
That part, my lord, yes, going by the, my lord, provisions of the act and the rules, that is a gray area, my lord. Probably, my lord, it's not there. I will have the instruction, my lord, what the government proposes to do, my lord, after this report has now been placed before them by the, my lord, duly constituted medical board in GMCS. That part, my lord, I can place it. But we'll have to do something, my lord, yes. It will have to be, my lord, brought down, my lord, or scaled down to 15% by modifying the certificate. Because 15% still remains. If at all it is holded, my lord,
50% remains another aspect, but the fact remains out there that how do you tackle this situation?
And my lord, some disabilities are progressive, my lord. It may, in due course of time, it may go down also. On the day when you was examined, he might be, my lord, 60% also. But after medication and all, my lord, if it goes down, then, my lord, it will be a different situation because it is
But
mentioned
how
in
do
the,
you take care of permanent?
that's why that board, my lord,
Therefore, the question is, permanent disability cannot scale down. It may go up only. Where is permanent disability mentioned?
yes, it is mentioned in the case of Mr. Das.
Where is permanent disability?
Lordship, on the certificate itself, you're also to find it, no?
As per the act.
In the act, or you can-
My lord, that lordship will find in 18.
Section.
No, the rule 18, my lord.
18.1.
Lordship will see forms, my lord, 5, 6 and 8, 7. That will be part of the rules. Lordship will see, my lord, page 74 of the act, my lord, thereof. Form 5, certificate of disability within bracket in case of amputation. Form 5. Form 6, in case of multiple disability.
Where, rule
Page-
18.
No,
Yes.
these are all the forms which have been annexed to the act itself, to the rules itself.
That's why, yes, it's
Page 73, 74, 75 of the, I don't know which book are we holding. Is you're also holding this book?
there.
No, he's holding there. I don't give you any ticket. देखो नहीं, देखो नहीं.
Form 5 is certificate of disability in case of amputation or complete
No,
permanent
next, my
paralysis.
lord, 7, page 76. Here, lordship will see, my lord, after the chart at page 77, clause number 2, immediately after the chart. The above condition is progressive slash non-progressive slash likely to improve slash not likely to improve. It's part of my lord form 7. Then my lord 3, reassessment of disability is 1, not necessary or is recommended after dash years, dash
No,
months
no,
and
this,
therefore
this certificate has been issued when?
in
23.
2021 and 23.
Now, this is 23.
Just 23, my lord, just prior to the advertisement. ma'am.
Minus 20. Not after. Minus 21. এইটো আছে চোৱা তুমি দেখুৱাই আছা এইটো দেখুৱাব লাগে
এইটো ইয়াত থাকিব not necessary.
No, no, her form will be form 6.
No, it will be 7, madam.
No, no, 6.
Multi.
No, no, for his case, Mr. Das' case, form 6. Because if you see form 6, kindly see, this is to certify that we have carefully examined so and so registration permanent so and so. He is a case of multiple disability.
Here it is only orthopedics, madam, not multiple. Locomotor.
Locomotor is here, na, affected by body parts.
A, B, C, A and B.
Okay, okay. So it will be 7.
7, madam.
7.
But why the certificate does not contain the other portion? The above condition is progressive, non-progressive, likely to improve, not likely to improve.
Says permanent. If you also look at the table above,
Huh?
the table on this corner, your lordships, it says here permanent stable. The table above that note, above note 4.
Not amended. 16 only, no.
And it says on the right hand side, the extreme right hand side corner says permanent physical impairment.
No, by why it is not in this form?
What is not in this form?
No, format 2 will not. Format 2 no, sir. Yes, it is not in the my lord format prescribed in the act or rules.
Why?
Split form 6, your lordships.
Form 6?
Form 6.
No, form 7 also.
7 also, serial number 1.
So, yeah.
Why it is not mentioned that, you see, locomotor disease affected part of the body, which part? That is also not mentioned in your case. Why?
It is mentioned, my lord. Case of distal and of right femur plus right lateral. Serial B.
Page number what, madam? Page
28.
This seems to be some different type of certificate. Huh?
No, lordship, so certificate is something else and the ID card is something else.
No, this certificate is not as per the rules. In your case, as per the rules.
Page 25, annexure A is my disability certificate.
Same format.
Locomotor disability, 45%. And it is a permanent disability in my case as well.
Your here is what? What is the name?
My name is Ashrafuddin Ahmed.
Your cousins? No.
I see, I'm not sure.
He's from Golbar, I am from Golakha.
Okay. No, the husband's name is also Samsuddin Ahmed and
I'm Ashrafuddin Ahmed, your husband got out.
No. Remind my street. Remind my son. Okay.
No, but my main question arises is this, na? So we need to that without cancellation of the certificate, can you, on the basis of some medical report, do it? Because otherwise the a certificate given us by giving us being given a statutory recognition would become useless. Anybody will jump into it. I think we should notice and stay to that, not to appoint that
Or one
fill up
post,
that
one
post. Yes, I think that is the way out. Issue notice making it returnable on. When can you file your affidavit?
Not, 3 weeks. Maybe even.
Issue notice making it returnable on 16th of March,
No.
2025, 26.
Let it be in February, my lord, at least.
February?
Yes.
Okay.
I'll do that.
You only ask more, then you say who is there and all these things. I would like to have it on 22nd itself.
Let it be, my lord, in the third week of February. But we'll try to file. At least
Can we,
medical reports and all.
can we have it on the 13th of February?
My lord.
Huh?
Yes, yes. No.
But you have to file your affidavit by 6th. 3 weeks. Okay. Issue notice making it returnable on 13/2/2026. Mr. B. Gogoi accepts notice on behalf of all the respondents.
No, my lord.
You can accept notice for everybody, na?
No, two, my lord, he's a standing counsel for the recruitment board, state level recruitment commission.
Okay.
1, 3, 4.
1, 3, 4, 5, 6,
1, 3, 4, 5, 6,
7, and 8.
7 and 8.
Mr. So-and-so accepts notice on behalf of respondent number 2. Huh? They will give it. The petitioner herein, extra copies by during the course of the day. The petitioner herein is aggrieved by the rejection of her candidature to the post of
The page 40, my lord. The post of grade category 1.
category 1,
My lord.
bachelor degree level, wherein the petitioner applied as a candidate as a PW W to Horu BD candidate. It is the case of the petitioner that the petitioner was issued the disability certificate on 19/5/2023 by the certifying authority authorized in terms with section 57(1) of the Rights of Person with Disabilities Act 2016, for short the Act of 2016, wherein it is duly mentioned that the petitioner has 40% permanent disability in relation to her right femur and right knee. Full stop. It is the further case of the petitioner that although in the advertisement dated 30/10/2023, there is no mention that there would be a further medical examination. But the petitioner, upon application and when provided with the provisional result was intimated that the petitioner has to undergo medical examination and clearance from the medical board constituted for that purpose. It is the further case of the petitioner that in pursuance thereto, the petitioner was intimated by the communication dated twenty
22, madam, page 14.
22/12/2025 that upon assessment being made by the medical board, it was found that the petitioner's disability is only to the extent of 15%, and as such, the petitioner does not fall within the ambit of the definition person with benchmark disability as defined in section 2R of the Act of 2016. The learned counsel appearing on behalf of the petitioner submitted that the certificate which have been issued to the petitioner, the disability certificate so issued to the petitioner, is in terms with Section 58 of the Act of 2016 and read with Rule 18 of the Rights of Persons with Disability Rules 2017, for short, the Rules of 2017. Pusto. The learned counsel appearing on behalf of the petitioner further submitted that in terms with Section 58(3) as well as Rule 18 of the Act of 2016 as well as Rule 18(4). Rule 18(4)?
18(3).
18(3). No, 18.
19.
Rule 19. Comma. The respondents cannot
Reassess,
Hmm?
reduce or reassess them, madam.
reassess or review the disability as mentioned in the certificate which have been issued. Unless and until the disability certificate so issued is cancelled or revoked or modified in accordance with law. Pusto. The learned counsel appearing on behalf of the petitioner further submitted that the decision of the medical board so constituted cannot override the disability certificate which have been issued to the petitioner. And accordingly, the rejection of the petitioner's candidature is apparently in conflict with the provisions of the Act of 2016 and the rules of 2017. Per contra, Mr. B. Gogoi, the learned additional advocate general appearing on behalf of the Health Department, as well as the other departments of the government of Assam submitted that the medical examination is done on the basis of an office memorandum dated of the government of Assam, which mandates that even if a person applies as a candidate in the quota of persons with benchmark disability, before issuance of the appointment order, there is a necessity for undergoing a medical examination. It is under such circumstances, in the provisional appointment order, provisional appointment,
Yes. Provisional select result.
provisional result.
Yes, result.
The petitioner, having applied as a PWBD candidate, was asked to carry out was asked to undergo medical examination. And upon medical examination, it was found that the petitioner the petitioner did not come within the ambit of the definition person with benchmark disability. He therefore submitted that the instant writ petition does not require, therefore submitted that the instant, full stop. This court had duly considered the respective submissions, and more particularly, the provision of section 58(3) of the Act of 2016 and Rule 19 of the Rules of 2017, which stipulates that the disability certificate so issued by the certifying authority would be valid. It is the prima facie opinion of this court that without revocation, modification, or alteration to the certificate, disability certificate, by the certifying authority, in accordance with the provisions of law, the respondent authorities cannot give a go-by to the said certificate. More so when the said certificate has a statutory recognition in terms with section 58(3) of the Act of 2016. Under such circumstances, this court is of the opinion that the petitioner herein is entitled to certain interim directions. Accordingly, this court observes that till the next date, the respondent authorities shall not fill up one post in the category of PWD.
Grade 3, madam, not grade 2. Grade 3.
Category, you are grade 3.
Yes, grade 3.
Why do you say grade 1?
You
means grade 3 already. Plus category 3. In the category 3, one post of PWBD reserved for a PWBD in category 3 till the next date.
Under the Labor and Welfare Department.
You have a love for Labor and Welfare Department?
It has been not, madam.
So what? They will give anywhere. And yours is education. And I'm not going well. Same case.
Intimated me about the reduction of my disability. It is a general notification which was published in the paper. That is how I have come to know. My learned friend has annexed a document in his writ petition wherein she has been categorically informed No such information was given to me, Your Lordships.
What
I
has
have
been
found-
informed?
I have found it in the newspapers when they have published in newspapers that my roll number figured in that.
As that you rejected.
That my candidate has been rejected because.
সেইটো সেই 2210 or 2210 তাৰ শুনলি লিখি দিব. The petitioner had come to learn from a newspaper advertisement dated.
Notice dated.
Is an advertisement.
3/1,
26.
3/1/2026.
Notice dated.
3120
26.
26.
Yes.
That her candidature has been rejected.
The respondents here, Education Department, my lord, he will appear for 1, 2, and 3. 1 and 2. I appear for 4 and 5.
Yes.
It's, yeah.
Please.
Asset 3, beach of review.
Any more matter of these types? There was another one. Yours matter. Your matter was? It has not come. Aru ahichi ni?
Yes. Same issue, madam.
And that I know. In the morning only you mentioned.
Same advertisement.
Same advertise, same thing. Yours is what? 40% of what?
Yes.
Madam, yours was also 40?
No, 45.
45, huh? 45 permanent disability asylum. Yours is
This is only madam cooperation department.
disability?
40.
40.
40.
Permanent?
40 permanent.
Permanent. Okay. And here, notice, have you been intimated about by the way of an order?
Next madam.
Order is there. 2010.
3/1/2026.
3/1/2026. এই তিনটা হৈ গ'ল, হা?
Your Lordship, I'm appearing on behalf of Miss Alicia Brown. She is on legs currently, so will the matter be taken up for some time? After some time, she is coming with.
পিছত মাতি দিব। বাকি মোশন মাতো।
Item 31.
And for non-payment of madam unleave encashment madam. At least this notice may be issued madam. I have challenged some particular order madam, page 87. Decided to madam leave it payment of the leave encashment benefit with effect from 1/5/2022.
Where's the impugn order?
Impugn order page 87 madam.
বাইচকল লোৱাৰ কাৰণে এটা অফেণ্ডেড তাৰমানে এইটোৱে
That custodian has not presented the resolution, my lord. I have enacted my lord resolution, my lord.
Now you are challenging 9/6.
My lord, 9/6, my lord.
Why are you challenging it?
But because my lord, with effect from 1/5/22, my lord. With effect from. But in the, my lord, the resolution of 117 minutes of meeting, my lord, I have annexed, my lord. That note cut off that has been prescribed, my lord. And we see, my lord, page 95, my lord. These are minutes of the meeting of 117 meeting of the board, my lord. Of the corporation.
Whether a minutes would have any relevance?
But my lord, this my lord works as employee, my lord. As receiving the all service benefit as per government rule, my lord. And subsequently, they were retired, my lord. After retirement, my lord, he has not paid, have not paid the leave encashment, my lord. And now, my lord, as per resolution, my lord, item resolution number 12, page 95, the board decided to pay the my lord, leave encashment to the works as employee. But impugn order prescribed the cut-off date, my lord. But in the 9/6.
Where is the minutes?
Minus, my lord, page 95, my lord. This is a type copy. And original copy 107.
Agenda? Item?
Agenda number, item number 12, please. Agenda item number 12.
Where is the High Court's decision?
High Court decision, my lord, so many decision, my lord, subsequently, my lord, kindly see, my lord, page 55, annexure 7. And operative case portion 666, my lord. That on that case, my lord, the issue arise, my lord, regarding, my lord, death of superannuation. On that issue, my lord, this honorable court, my lord, directed to pay the service benefit in terms of the court order.
Where is that?
review
Where is that paragraph?
Paragraph 29, my lord.
Huh?
Paragraph 29, page 66, my lord.
Page.
Retirement age.
There is a division bench order.
Appeal.
Secondly, division bench order, my lord. Annexure 8.
No, but the High Court's decision, the single judge's decision is what?
My
The
lord,
single judge were the impugned verdict that here that when the retirement age was raised earlier to the corporation, even the same was informed here. They have examined, therefore the departure made India did not find
This
favor with
16,
the
no?
court. We find no inquiry in the impugned decision granting relief to the works order and therefore we could please serve the board. What is this decision of 9-3?
my lord, 93, my lord, kindly see page 49, my lord. Review petition number 105 of 2003.
Where?
Page 49, my lord, and operative portion, my lord, page 50, my lord. In the earlier occasion, my lord, some of the workers already terminated, thereafter, my lord, approach before his honorable court. And this
The
honorable-
notice of termination is quashed, should absorb the so-and-so and if so-and-so next 5 years. The employees may in their discretion like to avail compensation of 1 lakh as ordered earlier in lieu of the service or avail the benefits under voluntary remand so-and-so. Where does it say anywhere about the service benefits?
My lord, in stated, my lord, it is review petition has not stated, my lord. But in my page 66, my lord, single bench order, my lord, subsequent.
No, it only says what? In
Service
about
benefits.
paragraph 20, say entitled to service benefits in terms with the order of the year passed in the year. No, here only says about 1 lakh.
My lord, if my lord desire to, my lord, seeking voluntary retirement, my lord.
Huh?
Seeking voluntary retirement, my lord.
So this order of page 29, paragraph 29,
My lord.
however, does not say about leave encashment.
So does not say, my lord, but.
So where is the basis to say about the High Court's decision on the minutes?
Minus it was stated, my lord, as per, my lord, High Court's decision, my lord.
So that is wrong.
But already they decided to pay the leave encashment, my lord.
So they are giving it, take that. What is there?
Notice may be issued, my lord. It may be.
For
my lord,
what?
Another, but High Court's order also, I have not, my
To
lord.
file another round of litigation.
The resolution taken in the 2022, 22 June, 9 June 2022, as per resolution, there is no service rules, my lord,
Huh?
regarding their conduct of employment. So page 87 is a minutes, my lord. As per minute, they've decided to give the benefits. 9/6/2022, Annexure 12. With effect from 1/5/2022, because the minutes was dated by April 2022, 29 April 2022. So next a month, my lord, they are giving the benefits, my lord.
So therefore, they are giving the benefit after that. How can you be given before that?
Because
They have never decided that aspect.
because our salary, all service benefits, as per government rules,
No, all are understood, but Mr. Counsel, the problem arises is where is this? Yes, Mr. Additional Advocate General.
clearly reflected in the appointment order also, my lord. The all payment, all
Mr. Nayak, what do you say?
Playground is there. In the resolution taken by the, there is no specification of the cutoff. Why sufficient will be? In the resolution.
They have for the first time taken a decision to grant leave encashment.
Yes.
Yes,
And-
forecast time.
Yes, ultimately, rightly or wrongly, they have taken a decision. And it was their impression that.
And therefore,
Direction was issued by the
and this happened in the month of April 2022. So immediately from 1/5/2022, they are giving the benefit.
And what I am rebutting, if is the argument that no specific cutoff date has been mentioned in this resolution, my argument will be there is no specific date as claimed by the petitioner has also been specified.
No, nothing is there.
So from that date, when it is decided, they have been paid. That is the only-
No, so therefore it is for the first time.
Yes.
A decision is being taken that these employees will be given the leave encashment. So it has been, on the basis of that decision, it is now being given with effect from 1/5.
After 2 days.
After taking the resolution, immediately from there,
Yeah.
the council comes to the.
Just for example, let us take an example. The fifth, 7 pay commission is being given. Now, the decision categorically says that we will be giving the decision on after the cabinet approves that. When a 7 pay commission came, the cabinet has approved that, yes, we accept it. And thereupon we'll fix a date from which it will be given.
That is the.
So this is how it is. So for the first time, the leave encashment question came only from 1/5 because it was decided in the minutes date in the April 2022.
That is the law. It is not specified in the order that it will give effect in retrospective manner. It will always be prospective.
Chalo, I think dismissed.
In my appointment letter, it is categorically stated that the salary, all service benefit, as per
Where?
government rules, in my appointment.
Where?
Page 28.
At that point of time, it was only worked out as.
Page 28,
Yes.
Page 28, Also says, on the basis of scale of pay as per month per other allowances as per state government rules in force. I have been receiving salaries, entire benefit as per government rules, And certainly,
No, you are getting a salary as per the government rules. There is no quarrel with that proposition. But the fact remains that there has to be, just for example, out there, you were appointed in the year 1984. At that point of time, did you get the GIS? Did you apply for the GIS? Why? GIS was there for government. Because this is to be adopted out there. Because this is a corporation, this is not the government.
But
Any other as per month plus other allowance as per the state government rules in respect to the salary. Just for example, tomorrow you may be the government says out there that these people may also be entitled because these Assam Housing Corporation cannot be the government. It may be an alter ego of the government, but this has to be approved. Similar like AIDC, ASIDC, we find a lot of cases out there where they have not given, just for example, the 6-pay commission, 7-pay commission has not been given in some corporations. So then,
But leave encashment also, my lord, is the, my lord, benefit reckoned from the my service, my lord. Because, my lord, government also,
You get leave encashment under what provision?
my lord.
Leave encashment is as per the leave rules or some the pension code? No.
Leave,
Let us see the leave rules where it says that you are entitled to, yeah.
my lord, for the government employee, my lord, it applicable, my lord.
Then you are not a government employee.
But, my lord, my salary has been already, all revision, all intelligence from the, my lord, as per government rules, my lord. My
But,
salary also revised, my lord.
Now, if you see the ROP rules of 2016 or 2010 or 2016, does it mention out there categorically that it will apply also to Assam Police Housing Corporation? No. It has to be again adopted. That case.
Fix on, my lord, after, immediately after, I will satisfy, my lord.
Huh?
I will satisfy, my lord. Immediately after.
Not satisfied. Mr. Sutia, you are satisfied?
I said, actually, corporation, they are depend upon the floating of monies from the receipt from the government also. They have no alternative. They are not government.
They are not government. Otherwise. Anyways, get your hold of the leave rules. When do you want it? Okay, let us have it on 27th. This is the matter on 27th at the request of Mr. K.R. Patri.
Yeah, in this expedition, my lord, I challenge the executive order, my lord, they have particularly closed the one and remand two, my lord. Page 45, my lord.
When did your father die, mother die? When did he die?
Died on 3/8/2015.
Huh?
3/8/2015, my lord. And I was recommended on 19/9/2023, my lord, by the district level committee, my lord. And my case is pending before.
Died on 3/8/2015. Then?
And I applied for completion of appointment on 27/9/2015, my lord.
Then?
And my case was recommended by the DLC from 19/9/2023, my lord. Thereafter, my lord, impugned office memorandum was issued on 19/9/2024, my lord. And I challenge this impugned office memorandum, my lord, by filing WBC number 5005/2025, my lord, which is pending before this.
So you want to go as per that 6/16/2015. That's your case. But how do you take care of that for the last 11 years, you are okay? Then that day I dismissed one of the cases, na? It is a matter case that dismissed with saying that if it being an exception to rule Article 16, then the office memorandum dated 1/6/2015 should be decided as it is. It includes the principle number 10, which stipulates that if your application is pending for more than 2 years, nothing remains.
Yes.
My case is already recommended.
Then what happened?
Then, my lord, office memorandum issued by the personnel department. I challenge this office memorandum, my lord, by filing WPC 5005/2025, my lord. It is still pending before this honorable court, my lord.
Which one?
Worship, page.
Where is that office memorandum of 38?
Worship 18/9/2020.
Page?
4, my lord. Page, page, my lord, 32, my lord. I challenge this office memorandum, my lord, by filing 5005/2025, my lord. This honorable court, my lord, issue notice, my lord.
Application basis. This is not necessary.
Well, in fact,
You are
like
not
he-
entitled to, I'm not going to
Yes,
issue a
well,
writ.
he is actually going to, well, praying for a direction for setting aside the SOP. In SOP is in fact in his favor because after passing of the writ petition 342 of the 2005, this SOP is issued by the government asking submitted application all the pending cases petitioner and we will consider accordingly. So he can submit his application.
I submitted.
And he submitted, then what is his case? They will consider it. Nothing else, my lord. The SOP is.
What do you want, a dismissal? I can dismiss, no way. Oh, you went on 9/9/2025. But Mr. Counsel, I have 2-3 judgments where I have dismissed it. Yesterday,
Yes,
na?
yes, yes.
Yeah.
I have forgotten
Yes,
the
sir,
number.
day before yesterday, I have dismissed one. The thing is, this compassionate appointment, after 2 years is over. What is there remains?
Spain is forced. Yes, yes.
What do you want? Means everything is finished
Yes.
the moment I dismiss it. Very well. Wait. Withdraw this petition and wait for some time.
Yes.
Better off. And the authorities are more kinder than me. Isn't it?
Yes, they are collecting all application, my lord, to consider. But he is, in spite of that, my lord, he is submitting it and coming for pursuing this.
Don't do that. You want to see that judgment order? That day I dismissed somebody. Dismiss person, na? কোনটো আছিল compassionate appointment এটা dismiss কৰিছো এইটো? এইটো number 2. Number 2. এইটো এই অৰ্ডাৰটো ওলাই দিয়কচোন 6410/2025. You want this order? I can very well dismiss it. Mr. Sutia, you were there, na? That day.
Yes, yes, I was there. I remember.
Yes.
But I forgotten the number.
Let us dismiss his case also.
Yes.
What do you want? Withdraw. Mr. H.A. Loskor, the learned heard Mr. H.A. Loskor, the learned counsel appearing on behalf of the petitioner, Mr. T.C. Sutia, the learned counsel, additional advocate, senior government advocate appears on behalf of the respondents. Mr. So-and-so, the learned counsel submits that taking into account that the petitioner has submitted an application on 9/9/2025 pursuant to the notification dated 30/8/2025. The petitioner would be well advised not to further pursue with the instant writ petition and await the decision of the government in the said application. So taking into account the above, the instant writ petition stands closed on withdrawal without prejudice to the rights of the petitioner in respect to the application filed on 9/9/2025. Order 2. Mr. Sutia, you take this. Next time you show it to me.
Yes.
Yes, Mr. Bora. Come again, 5/9.
Our candidature was rejected on account of height.
Height?
Yes, your lordship will sign the rejection order.
Height, medical opinion can't help it.
Lordship, there is a provision with regard to height.
Yours is 154.5.
Now, when there is 5.5 is there, it has to be rounded up to the next half point. Lordship. So 154.5 has to be rounded up to 155.
And what should be the necessity?
155 for female. And she is
Huh?
female.
For female, 155 is the lowest.
Then why you are not filing an appeal?
But if the appeal, there is no provision of appeal.
Page 43.
Yes, provision is there, Lordship.
You enclose this document and you say there is no provision.
Fine, but this was rejected, but it was.
Where? Where it is
Because
rejected?
because they provide the form on the same day and the candidate.
When did you file an appeal?
Before the presiding officer of the recruitment body. Lordship.
When?
On the same day, it has to be. filed
Show
on
me the
same day.
statement where you have filed the appeal.
Page number 3, page number 5, Lordship, para 3.
No. Kindly see, page 43. Your candidature for a post of so and so for the year AI is rejected on the following grounds. Whatever may be. If you are not satisfied with the ground of rejection dated here, then you may prefer an appeal in writing to the appellate authority on the same day through the presiding officer. The decision of the appellate will be final and no further representation. There is no appeal in pet race. Yes. Where did you file 154.6? In your petition, you have put 154.6, whereas it is glaringly appearing that 154.5.
That Lordship probably typing mistake.
Huh?
That I.
One. Secondly, kindly come to page 6. How? Why do you mention that an appeal was filed and for which the candidature was an impugned rejection slip was issued? Meaning thereby what? It seems to be wrong. Don't you think so? Where is it 154.5?
Lordship, page 42.
Guidelines. Where is it?
46. Lord.
Female. Height, page 28, 157.
No, that is not applicable.
Why it is not applicable? Then why you are enclosing this document?
Page 28.
Page 28.
Yes.
Female 157.
D.
Huh?
D, Lordship. Serial number D.
Falling in the categories of Garwal, Kumaon, so and so, 155. You belong to this.
State of Assam.
Assam, state of.
And candidates belonging to the state
And Indian Territory
of
Assam,
India,
Himachal,
155.
Jammu and Kashmir, 155.
Belong to northeastern states of Arunachal, Manipur, Meghalaya. What is your name? Pathak. You are 155. Now, why do you say that it has to be rounded out?
Because at page 46. page
Because
number-
why I'm saying so, it can't be rounded out because they use the word female 152.5 also. They could have mentioned as 153. Kindly come down, page 28. They could have mentioned as 153 if your contention is to be accepted.
Page 46. Page 46. The guideline of the respondent. Page 46.
46, yes.
This is medical guideline, Lordship.
This is medical guideline.
This is medical guideline.
Medical guidelines has no business.
This issue has already been settled by this honorable court.
Where?
May I please get the.
Show me.
That same argument was made by the respondents and that was rejected.
This is medical guideline, Lordship. That submission was made at the time of hearing, Lordship, in depth matter. But
And it was rejected.
This
That
was,
submission was rejected by this honorable.
This relates to medical.
It is clearly mentioned, Lordship, in page number 30 of the writ petition, Lordship.
Para number 11 to 18 are the given paragraphs.
so I'm bound by this.
Yes, otherwise it will covered, but
Have you filed appeal?
no, Lordship.
Although I don't agree, but I am bound by this. Isn't it?
Yes, Lordship.
Who will they allow his petition? What is there? You have not filed an appeal against this. Have you filed?
No, Lordship, not filed.
I don't want to do, because you see uniform for medical examination tests for recruitment restricted, but here one thing, general instructions it
Clearly
categorically
mentioned,
says
Lordship.
measurement of physical standards,
Yes,
height,
Lordship.
weight, chest in the responsibility
BMI also.
of the physical board, and for all categories of candidates, medical officers will not be a part of PST board of so and so, since presence of female is required at the time of recording physical standard. A female non-medical may be associated with PST board. Recruiting medical officers need not record to the physical measurement. Recruiting medical officers will mention physical standards in so and so. In borderline cases of overweight, BMI should be considered to arrive at the conclusion of plus 5 kg plus minus from the Iman. Similarly, while measuring height fraction of cm, less than 0.5 will be ignored and 0.5 and more will be rounded off to the next higher cm. Standard height weight chart is attached to Annexure 1. So, can't help it.
It is clearly.
Let's allow his petition. Heard Mr. R.B. Bora, the learned counsel, appearing on behalf of the petitioner.
Otherwise,
Ms. S. Burwa appears on behalf of the respondents, numbers 1 to 5.
Delhi High Court judgment is there, Lordship, where it is a similar case. Delhi High Court judgment is there.
They say,
A similar case not allowed, Lordship. Dismiss this petition.
no, I can't, problem arises
Yes,
because
yes,
of this
Lordship.
judgment. No?
Yes, Lordship.
This I'm bound.
Yes, Lordship.
That is persuasive. And I also think,
Yes.
because your basic thing, why for Arunachal people, you have put at 152.5.
Yes.
You could have made it 153.
Not rounded up.
But they have not considered this guideline. Oh yeah, it is considered. Therefore said clause 2D is clear as noonday that the relaxation which is required to be considered at the stage of detailed examination, there is no concession or relaxation in respect of physical standards and so and so. But, madam, do you understand, appreciate one thing? Punjab and Haryana and Calcutta has held
Karnataka also.
alike what Justice Etye has held.
That is not precedent, not to be taken as precedent. It is also may mention that judgment.
Yes, paragraph 17, they say the judgments relied upon by the respondent passed in Kuldeep and so, or the judgments passed by different high courts are not binding on this court. If this is not binding, such disregard is made to other high court judgment, then why should I follow that?
In fact, the Calcutta High Court judgment is passed by the division bench.
That is
I
also,
think-
here also that is mentioned. But kindly, now recently informed me, SS Royal Lordship, that we are going to file appeal. Kindly issue notice, Lordship.
Where?
Uh,
File an appeal along with this. 2 appeals. Isn't it? But the law is very clear. Heard Mr. R.B. Bora, the learned counsel appearing on behalf of R. Bora. Okay, it's not a dismissal, so I don't put the B out there. R. Bora, the learned counsel appearing on behalf of the petitioner, Ms. S. Bulwa appears on behalf of the respondents. The petitioner herein is aggrieved by the rejection of the petitioner's candidature on the ground that the petitioner height is below the prescribed limit. Full stop. The facts of the instant case, as is apparent from the materials on record, is that in pursuance to a notice dated 5/9/2024 for recruitment to the post of Constable GD in Central Armed Police Forces (CAPFS) and SSF, Rifleman GD in Assam Rifles and Sepoy in Narcotics Control Bureau Examination 2025. The petitioner participated in the said recruitment process for the post of Constable GD, isn't it? Constable GD. Full stop. It is very pertinent to take note of that clause 12.5 stipulates the physical standard test, bracket PST. Full stop. The said clause 12.5.1 deals with height, which being relevant is reproduced herein under page 28 or 29 or so. Full stop. From a perusal of the above quoted clause, it would be seen that for female, the height is 157 cm in terms with clause 12.5.1.2. However, there are certain relaxed standards of heights for such candidates, for certain categories of candidates. For example, if the candidate belongs to the states / Union Territories or state of Assam, the height for a female candidate is 155 cm. Full stop. The petitioner height was measured and it was found that the height of the petitioner was 154.6 cm And as such, the petitioner was disqualified in the physical standard test. It is under such circumstances the petitioner has approached this court. The learned counsel appearing on behalf of the petitioner has submitted that taking into account that the petitioner's height is 154.6 cm, comma, in terms with the uniform guidelines for medical examination met for recruitment in CAAPF, comma, NSG and AR, more particularly clause 2D, the height of the petitioner should have been rounded up to 155 cm, in as much as the petitioner's height was 154.6 cm. In that regard, the learned counsel also referred to a judgment of the coordinate bench in the case of Orup Ray versus the Union of India and others, WPC number 6436/2025, dated 22/12/2025, wherein also the learned coordinate bench of this court held that in terms with clause 2D of the guidelines dated 25/2025, 15, if the height was 0.5 cm, comma, it should be, if the height, the height fraction of 0.5 cm and more is required to be rounded off to the next higher cm. Full stop. Paragraph 13, 14, 15. (16, 17, and 18) being relevant. 16 and 17 being relevant are reproduced herein under. Next. The issue in the instant proceedings being already adjudicated by a learned coordinate bench of this court, comma, this court is bound by the said judgment. The observations made in the said judgment. Accordingly, this court is also therefore apart from that, comma, this court, having perused clause 2D of the guidelines dated 25/2015, is also of the opinion that the fraction of 0.5 cm in and above is required to be rounded up to the next higher cm, as it is the mandate of the said clause. Considering the above, comma, as the height of the petitioner is 154.6 cm, comma, by applying clause 2D of the guidelines dated 25/2015, comma, the height of the petitioner would be 155 cm, and taking into account that the petitioner hails from the state of Assam, comma, it is the requisite height minimum requisite height in terms with clause 12.5 12.1.3 bracket D of the notice dated 5/9/2024. Pusto. Accordingly, this court therefore sets aside the impugned rejection dated 10/9/2025 and directs the respondent authorities to consider the petitioner consider the case of the petitioner for appointment to the post of the Constable GD without being influenced by the
May I please,
rejection
Lordship?
dated 10/9/2020.
One observation is there, Lordship. He was not clear after that completion of PST, he had to be appear before DME, Lordship. Medical examination appointment should not be.
I'm not saying
Yes, Lordship.
what did I say? Shall consider the case of the petitioner for appointment
Yes.
to the year without insisting on the rejection dated 10/9/2000. I'm not asking them.
Obliged, Lordship.
Consider the case of the petitioners for appointment to the post of without insisting on
Further,
and subject to further. And so before parting with the record, this court, however, clarifies that the respondent authorities shall, the above directions shall not preclude the respondent authorities to carry out other tests, viz. Medical examination,
DME,
etc.
DME, detailed medical examination and
Medical examination, etc. if so required as per the notice dated 5/9/2024.
Your Lordship, the petitioner unit is agreed by the transfer order issued by the Joint Director of Health Service, Your Lordship. So the petitioner is moving the transfer order on a few grounds, Your Lordship. Firstly,
Where is the transfer order?
19, Your Lordship. An extra one.
From?
From the
What is the name of the petitioner?
Suleiman Hussain.
Huh?
Suleiman Hussain. Number 1, serial number 1.
Suleiman Hussain. It's a different type of spelling, huh? CHU. Normally we see SU. CHU Suleiman is a PHC accountant come so and so. Hospital Belsor to Dosal MPC. Then what is wrong?
Your Lordship, it is in violation of the order passed by the mission director, which is the next annexure, Your Lordship. If Your Lordship peruses the third paragraph of the order, Your Lordship.
Let's come to the notice of the undersigned of the National Health so and so are transferred or attached to other institutions hampering the services in the original place and also in violation. There will be no transfer attachment of the employees and a shall be issued by the Joint Director of Health Service or any subordinate officers as their so and so. Need for rationalization. Yes. Mr. Gugoi?
Well, the order is of November 2025. Now, my lord.
No, but this is, I think there must have been some change. Anyways, we do one thing. We'll issue a notice, short notice. We won't stay this now. There's no urgency out there, having approached this court after such a long time. Let's,
Page 24.
then,
So no call has been taken on it, yes. Your Lordship.
then what happened?
Which is why the petitioner has approached us on.
Then what happened?
Your Lordship, page 24.
Anyways, no heavens will fall. On 21st, let's have it on
Well-
21st to get your instructions.
In case in the meantime, if the respondent number 4, if he joins in, Your Lordship, then the petitioner will be released, Your Lordship. Which is why.
Madam, you could wait all the while from 1411. Celebrate your New Year's at Belsor.
Your Lordship, because the representation.
Now
is
you
already-
don't like to go to Somota. Somota, how far is it? Belsor, Somota?
35 kilometers from the place where the petitioner is residing. Also, he has only 9 months of service left, Your Lordship.
Oh, they will consider that. Issue notice making it returnable on 21/1/2026. Mr. B. Gogoi accepts notice on behalf of the respondent numbers 1, 2, and 3. Full stop. For the time being, this court is not inclined to issue notice upon the respondent number 4. Full stop. The petitioner herein is aggrieved by the order dated 14/11/2025, whereby the petitioner has been transferred from BPHC Somota. Huh? What is this?
Block PH.
How do you read this? Like, all are different. Means I don't understand. Oh, okay. From BPHC Somota to BPHC Mukalmua.
Yes.
And the respondent number 4 have been transferred from BPHC Mukalmua to BPHC Somota. Full stop. The case of the petitioner herein is that the said transfer order is contrary to the earlier order passed by the Mission Director, National Health Mission, dated 30/8/2022, wherein it is mentioned that the Joint Director of Health Service is not permitted to issue transfer orders. The learned counsel appearing on behalf of the petitioner further submitted that on 3rd of December 2025, the petitioner had submitted a representation to the mission director, NHM. However, the same have not yet been redressed. The petitioner's case has not yet been redressed. Full stop. The learned counsel, full stop, this court, taking into account that the transfer order was issued as far back as on 14/11/2025, is not inclined to pass any interim directions till without first giving the respondent authorities an opportunity to apprise this court the reason as to whether the transfer order is in violation to the communication dated 30/8/2022 or order dated 30/8/2022. In order, taking into account the above, Mr. B. Gogoi, the learned additional advocate general, shall apprise this court as to why the transfer order, as to whether the transfer order dated 14/11/2025 is required to be interfered with.
Your Lordship, may I?
Why the transfer order dated 14/11/2025 should not be interfered.
Your Lordship, I understand Your Lordship is not inclined to say the matter. Your Lordship, but in case if the petitioner is released from here, Your Lordship, he has only 9 months of service left, Your Lordship, and it will only go to and fro. Which is why I was praying for a stay at least until the next date, Your Lordship, till the 21st.
Madam, no. Transfer should have been immediate. You have approached
Representation.
1 month, 2 months, almost 2 months are over.
So Your Lordship, he was waiting because he had already given the representation on.
You gave the representation on 3/12
Yes.
and then also nothing happened. You fear that in view of the filing of the writ petition, there might be any action to that effect. Don't worry, nothing is going to happen.
Lovely.
Dismissal by constable, my lord. Yes, sir. Termination.
What happened? What is this case?
Here the internal appointed a constable in the
Dismissed.
high department of the CSF, madam. And he belonged to OBC. Surprisingly, how they find the certificate fake. But the CA is already the OBC board.
You have been terminated
Yes. No,
on the ground?
on the
Fake OBC certificate.
fake.
Fake OBC certificate.
Yes. Certificate is of the DC also certified, only it is not fake, it's genuine. And then I presented, so rejected again, second five, that was also rejected. Notice of the market.
Okay, Mr. Sharma, let's have this matter again on 20. 21st. Let's have it. You get your instructions. We'll have it on 21st. This is the matter on 21/1/2024. Any urgent motion matters which are required to be moved today? Because I'll have to rise at 4:15.
Item number 52 and 53. 52 minutes, I won't be pressing this, my lord, because I had mounted a challenge to a transfer order. The petition has already joined. And the another 153.
No, one is Mr. I.S. Saikya's matter, na? Your matter is there. As to regarding that Gaubura thing, isn't it? I'll take it, wait. He's the one more. Let us first take up Mr. I.S. Saikya's matter. Yesterday I heard it.
Yes.
Otherwise, 55.
51 may be listed for admission. The notice has already been issued.
51.
Yes, ma'am.
51, it has been wrongly listed as submitted by Mr. Isamua. List the matter for admission on when? When do you want?
After the vacation period.
On 9th of February 2026.
Similar prayer, my lord. 52, I'm withdrawing it. 53 will come for admission because they filed the affidavit.
53 for admission. Whether notice has been issued.
One case notice was issued.
Which one?
5016. 5016.
Affidavit also filed.
Notice has been issued.
Issued, my lord.
So 52 you are withdrawing.
Yes, ma'am.
Mr. D. Gogoi, the
53,
learned
53,
counsel
ma'am.
appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Ms. B. Sharma appears on behalf of the respondent.
53, no?
Taking into account the above, the writ petition stands closed on withdrawal. 53 to the board, list the matter on 13th of February 2026. The respondent shall file the affidavit.
They have filed, my lord.
Petitioner given the liberty to file reply.
Yes,
For
52
admission,
is
huh?
52. 7006 withdraws.
Yeah.
53 is withdrawn.
Understood. 53, this is the order.
Yes, ma'am. Yes.
On 13th of February and respondent, the writ petition has been wrongly listed for motion. So list this matter for admission on 13/2/2026. Full stop. The respondents have already filed their affidavit. Petitioner given liberty to file reply if any.
Well, there's an interim.
The interim order stands extended till the next date.
The
Oh, listen.
next one,
Next day.
second one, lordship, that interim may be vacated. Already
No, no.
he has joined.
সেইটো
But
সেইটো
Vitometer,
সেইটো উল্টা
Vitometer.
কৰিলো সেইটো উল্টা কৰি আছে
Vitometer, the interim may be vacated.
Which one?
The withdrawn matter, the other one.
52 I had to
Interim order if any stand vacant.
Always.
Okay. 54 D Deca, what matter is that, Mr. D Deca? Disposed. 55. Yes, his matter. Yes, what do you say? Why you have not disposed of the appeal? The review petition he has filed. Now here is the case. You must be aware of it. Have you disposed of the appeal, review petition?
Not disposed of yet, Lordship.
But what has happened in the meantime? They have appointed them.
Lordship, I got it.
Then what do you do?
Can I see that? instruction,
I'd
Lordship.
like to request you to refer to clause A of the above mentioned wherein the circle officer so and so dated him and appointed so and so as in the Gaon Pradhan and was allowed to assist the in charge Pradhan so and so. He therefore submitted the Sahara wife of so and so was allowed to assist the in charge Gaon Pradhan related to the works purely on temporary basis and also no revenue was paid for the Gaon Pradhan related works and it was already mentioned in the order dated demand by the server that no claim regarding permanent appointment made. So this is your instruction, but why does it say that on 5/1/2026, where is that communication? What are these?
109.
109. Consequent upon the advertisement dated so and so, speaking order dated demand by the field number so and so and interseria so and so is hereby appointed as Gaon
Yes,
Pradhan.
sir.
Isn't yours contrary to what is being given?
Disabled.
Isn't it contrary to your instructions?
Lordship, since their instruction is that since there is no stay order, there is no stay order from this court, Lordship. Under that circumstances, just additional.
No. The question is like this.
Lordship.
The court, when he first filed a writ petition challenging his appointment or his selection, the court says that in view of section 162D, directed him to go and file a review. And further said that till he files the review, he's protected.
No, Lordship, not. The first.
Only 7 days, madam.
Only 7 days.
Till he files. And no, the 7 days was given time for him to file the review also. And further, the last line says of the order that the review authority is also empowered to grant stay or interim orders. Now he files the review within the time stipulated. You don't take any action in that. It is under process you have kept it. On the other hand, you appoint him. What is this?
The appointment order was issued by this additional district commissioner, Lordship. Appointment order was issued by the additional district commissioner, Lordship.
No, whoever may be, are they not aware that this appeal, the deputy secretary's revenue department writes something else? And it seems that deputy secretary, the revenue department has no knowledge what is going on. On one hand, he is taking up a review petition. What does that have? We take it up again on 21st.
Lordship.
Obtain your instructions on this. Short notice.
Lordship.
On 21st. Don't worry. I'll take care of it.
Otherwise, initial order, he was not engaged as in such Gamba.
I'm not on that. I'm not on that. On one hand, you have not passed any interim directions.
Lordship.
Your instructions are different from what the deputy commissioner is doing. So here, what you say, in view of the above, it is therefore submitted that Sahara Khatun, who is Sahara Khatun?
Petitioner.
Sahara Khatun, wife of so-and-so, the previous Gaon Pradhan of so-and-so was allowed to assist the in charge so-and-so in the Gaon Pradhan related work purely on temporary and also no remuneration was paid for the said Gaon Pradhan related works, and it was also mentioned in the order by the circle officer that say no claim regarding permanent appointment for the same shall be made.
Lordship.
It's okay. Further, the review petition which have been submitted by the petitioner is under process. But why in the meantime you have done all these things? Issue notice making it returnable on 21/1/2026. Mr. S. Dotto accepts notice on behalf of respondent number 1, 2, 3.
1, 2, and 3.
Mr. T.C. Sutia accepts, the learned additional senior government advocate accepts notice on behalf of the respondent number 4, 5, and 6. Mr. Sutia, here you have to take it up with that. You see, while an appeal is being pending before the commissioner and secretary, You have on your own appointed made certain appointment. 4, 5, and 6. Mr. R. Islam Ali appears on behalf of respondent number 7. Extra copies of the writ petition be served upon them during the course of the day. The petitioner herein is aggrieved by the inaction on the part of the respondent number appeal file 2, on the part of the respondent number 2 in not taking up the review petition so filed pursuant to the order passed by this court dated
Nineteen
19/11/2025 in WPC number 6534/2025. And further, the respondent number 5 and the respondent number 6 appointing the respondent number 7 as the Gaon Pradhan in the charge number 12 of Bagbor Moja under Bagmore Revenue Circle, and handing over this charge to the respondent number 12, respondent number 7. Pustak. The respondent herein, more particularly the respondent number 2, shall apprise this court as to why the review petition, which have been filed as far back as on
25/11.
25
11. 25/11/25.
dated
25/11/25.
25/11/2025 have not yet been decided yet, have not yet been decided. So on the next day, this court shall further consider as to whether there is a necessity for issuance of interim directions.
Lovely.
KVS stands discharged. Yes, it returns. Yes. SC Biswas, what is your case? They list the matter on 21/1/2025. Yes, what is this?
Yes, this case, my lord, petitioner has been placed under suspension second time, my lord. Second time in connection with same offence, my lord.
Suspended?
Yes, my lord, second occasion. Earlier suspension was set aside by this honorable court. My lord, it's last page 39, my lord.
কি বাবা 56 এটা নো 56 under rule 61C lordship, that is followed issued, that can be my lord.
Okay, let us issue notice.
Yes, under rule 61C, that can be my lord, where criminal case.
I know that.
Yes, sir.
Can we? Issue notice making it returnable on 28th of January.
I am for only responsible to my lord.
Okay, 28th of January 2025, 26. You don't appear for
GAD F. Foucault, my lord.
Okay. Mr. This Gad is, I think, he's the standing counsel.
F. Foucault, my lord. F. Foucault.
B. Gogoi is also the standing.
They also appear.
Isn't it, Mr.
B. Gogoi?
For GAD, I think General Administrative
GAD,
Department, B. Gogoi is there, na?
B. Gogoi.
And also A. Phukon.
A. Phukon.
All these things are there. Mr. B. Gogoi accepts notice on behalf of the respondent number 1 and Mr. T.C. Suti accepts notice on behalf of the respondent number 2. The petitioner is aggrieved by the order dated 22/12/2025, whereby the petitioner has been put into suspension. Petitioner has been suspended again after the earlier suspension order having been revoked by this court. Full stop. The respondents herein shall apprise this court as to under what circumstances the petitioner had been suspended. In that regard, had been again suspended. Is the matter again, no, full stop. The same be done by providing necessary instructions on the next date. You have the audacity to ask. Chal. Anyways, all other urgent matters, if any, you kindly give it out there. We'll have it on some other date. Yes.
Number 40.
40?
Because it's related to OBC NCL issue. Your Lordship has already directed others to withdraw the matters.
You want to withdraw? What did I do? Oh, OBC, that one.
Challenge of 6.5 of that.
Huh?
Challenge.
Oh, 6.5, na? I think that is a better order. Okay, hetu withdraw kori dibo. Ha, aji ratipuwa je motion ketaman asil. Ha? Hey, agor matter ketaman asil. Item number. Hey, item number 8 logot milibo. Withdraw hobo, ha? 40, na?
I am appearing for.
So and so.
Lordship 43, I think, contempt matter. And a date be fixed now.
Okay, take the dates. We will give it to you.